Participants, we shall be live streaming the same event on the university page. If there being no objections to the same. Thank you. We shall be starting in a minute. Speaker 2, opposition and speaker, can you please switch on your cameras?
Hi, Pranav. Before this begins, can you just remind me which team is petitioner and which team is respondent between 1 and 2?
Sure. Participants, would you like to clarify yourselves?
Your Honor, we team code 01 are arguing on behalf of the informants.
And team code 02 on behalf of the opposite parties, Your Honor.
Thank you.
Your honors, have the memorials and the compendiums been made available of both the teams to you? Your honors?
I have, yeah.
Okay, perfect.
I mean, just a memorial. There is no companion which I have. There is a memorial, right?
Oh, okay. I'll just, can the teams just share the compendium links in the chat box for the convenience of the judges? Team 1 compendium is now available in the chat box. Team 2? Perfect. All right. With that, I now proceed. Good morning to all the judges and participants. I warmly, on behalf of the university administration and the organizing committee, welcome you to the final round of the 5th Jindal Moot Court competition. Now, it is my absolute pleasure to introduce our esteemed panel for the final rounds for those joining us on YouTube and to all the members present in the courtroom. In front of the Competition Commission of Aristram today, we have Mr. Samir Gandhi, Senior Partner and the Head of Competition Law Practice at AZBM Partners, who will be serving as the Chairperson of the Commission of the Competition Commission of Aristram today. The other honorable members of the Commission are Ms. Diksha Manchanda, who is a partner at Chandni Hoke and Mahajan Advocates and Solicitors and had agreed to draft the proposition of the moot and is the problem author. Mr. Parasarathi Jha, who is a partner at Economic Laws Practice and a part of the competition team at Economics Law Practice. And finally, Mr. Pranjal Pratik, partner at Khaitan & Co. and part of the competition team at Khaitan. Today, Team 1 would be arguing on behalf of the informants, and Team 2 would be arguing on behalf of the opposite or the responding party before this commission. Now, without further ado, with the consent of the judges, I would invite the informants to begin with the proceedings.
If your honors permit, may the council begin with the submissions?
Please proceed.
Your Honor, the matter before this honorable commission involves a big e-commerce platform abusing its dominant position in the relevant market, as well as the cartel which has been functioning through it. If it pleases your honor, this is the co-counsel appearing on behalf of the informant, Starfox Cooperative and others. In the course of next 19 minutes, it will be my endeavor to present before this honorable commission two main submissions. Firstly, that Celestial is dominant in the relevant market, and secondly, it has abused its dominance in that relevant market. And my co-counsel in the remaining 24 minutes will be addressing how, firstly, the 4 toy manufacturers formed a cartel, and secondly, how Celestial and Black Knight has facilitated this cartel. Now, if there are no preliminary queries from members of the commission, the council seeks permission to proceed with the first submission that Celestial has abused its dominance in the relevant market.
Please proceed.
Much obliged, Your Honor. Before moving to the issue of dominance, the council would like to first delineate the geographical and the product market, and in which Celestial has abused its dominance. Your Honor, the geographical market here in the pan-Aristam, as the competition was homogeneous throughout the country, and the product market, Your Honor, the council contends that the definition given in the DG report should be altered, and it should be placed as online marketplace for services provided by retailers for selling toys in Aristam. Why the council contends so? Because if we go by the definition given in DG report, it may include both online and offline, but these are two distinct markets and cannot be clubbed in a single relevant market. That's why council contends that the relevant market should be the online marketplace, and it should exclude the offline market in the relevant marketplace. Now, if there are no other queries from Your Honor, may the council proceed to the first submission, that how Celestial was dominant in the relevant market.
Council, on the relevant market, what are the factors that you think we should consider to define an online market as distinct from the offline? At the end of the day, from a consumer point of view, they both seem to be the same to me.
Your Honor, for that, the council would like to refer to Section 2T of the Competition Act, wherein it has been stated that for two products to be kept in a similar relevant market, there has to be a substitutability and interchangeability between the two relevant markets. Now, if we compare the two markets herein, one is the online marketplace and one is the traditional offline market. These are two very distinct markets, because as we see, online market provides a convenience a range of products to a consumer, whereas on the other side, traditional brick and mortar stores are very different if we compare it to online marketplaces, because it does not provide such conveniences. So they cannot be substituted under any circumstances.
So Celestial is a platform. You agree with that?
Yes, Your Honor.
And the conduct that we're referring to, which side of the market does that conduct impact?
Your Honor, we are referring to the online marketplace.
Okay, but the online marketplace serves wholesalers or manufacturers, plus it serves consumers. So from the wholesaler and manufacturer's perspective, even if I accept that from a consumer perspective, there's a difference, from the wholesaler and manufacturer perspective, how do you think it's distinct enough for it to be different markets?
Your Honor, on the seller's perspective, if we compare it to the seller's perspective, there is a difference in distribution system if we compare an online platform to the traditional brick and mortar stores, because of the geographical reach of the two different relevant markets. If we compare Celestial, it had a distribution system throughout the country, whereas if we compare it to a traditional brick and mortar stores, it is only confined to a particular geographical areas. Hence, on the seller's perspective too, it creates a distinction between two markets. If it satisfies Your Honor's question.
Do you have any authority which you can support? Because we are bound by something that the Commission of India has said, and they say they are channels of distribution and not two distinct markets. So how do we get over that?
Your Honor, for that, the council would rely on the case of All India Online Vendors Association versus Flipkart, wherein it was stated that although the distinction between online store and offline store is blurry, but an online platform provides convenience for both sellers and buyers. And hence, the Competition Commission of India, whose laws are pari material to the country of Aristam, created a distinction between an online market and an offline market in this particular case. Also, Your Honor, the council would also like to refer to the case of Justice versus Big Tree Entertainment, the case of 2016 of Competition Commission of India, wherein the Competition Commission has created a distinction between brick and mortar stores and an online marketplace. And in paragraph 23 of the same case has stated that although they are complementary, but they are different markets. If it satisfies Your Honor's query.
Yeah, please proceed.
Moving to my first issue, that how Celestial was dominant in the relevant market. Your Honor, for that, the council has 4 arguments. Moving to my first argument, that Celestial held a substantial market share in the relevant market. Your Honor, if we refer to paragraph 4 of the Moot proposition, it is clearly stated that Celestial, as an e-commerce platform, held significant market share in the e-commerce as an e-commerce platform. Now, if that fact accompanied with the fact that we see in paragraph 9 and 10, that the businesses as well as these 4 toy manufacturers which are in the present relevant market were forced, the emphasis ought to be the use of the word forced, were forced to list on the platform for the commercial advantage. Your Honor, that clearly establishes the fact that that Celestial held such high substantial market share in the relevant market to term it as a dominant entity. Your Honor, along with that, coming to my second submission.
Sorry, which paragraph you referred in the proposition on forced?
Your Honor, it is given in paragraph 10 of the Moot proposition.
Counsel, you mentioned that with lockdown, they were forced to switch to online, but is that enough to say that they are in a dominant position?
No, Your Honor. Although a substantial market share is one of the relevant factors as given in Section 19 Clause 4 of the Competition Act to assess dominance of an entity, but in the course of the further argument, the Council will delineate how all other relevant factors given in Section 19(4) are also satisfied to term it as a dominant entity in this relevant market.
And we're talking about toys here, right? Catering to online retailers for toys. So how do you satisfy dominant position with respect to that specific product segment and not generally online market?
Indeed, Your Honor. Your Honor, as the Council already stated that as an e-commerce platform, Celestial had a substantial market share. Now, the four manufacturers, which held the 85% of the market share, their whole business was mainly shifted to Celestial. Also, Your Lordship, along with that, the cooperatives, which was the conglomerate of unorganized sectors, their business were also shifted to Celestial. Hence, Your Honor, these facts clearly establish the point that their businesses were mainly shifted to Celestial. It would have as it has a wider customer base, it would have such high substantial market share to term it as a dominant entity in this market. To satisfy Your Honor's query.
Yes, please go ahead.
Much obliged, Your Honor. Now, coming to my second submission, that the size and resources of Celestial created entry barrier for other players in this relevant market. Your Honor, an important indicator of dominance is financial strength as well as the network effect generated by the big e-commerce platforms and the commercial advantages gained by it. Your Honor, if we refer to paragraph 8 of the Moot proposition, there is a market study given therein. It has been clearly stated that customers mainly prefer Celestial as an e-commerce platform. Also, Your Honor, if we see it has been given in the DG report that had been stated that the four toy manufacturer wanted to compete with Celestial, but they couldn't compete the might and because of the size and resources and the discount offered by Celestial. You know, that clearly established the fact that if any new entity had to enter this relevant market, they would, to counter the size and resources and distribution system of Celestial, there would be a huge capital cost of entry. And due to the reputation of Celestial, there would be high marketing entry barrier. Along with that, because of the distribution system, there would be economies of scale and a high financial risk involved. Hence, Your Honor, the Council contends that it would create an entry barrier for any new entrant to enter into the relevant market. Now, if Your Honor permit, may the Council proceed to the third submission that buyer lacked the countervailing buyer power against Celestial.
Sorry, just before that, a quick question. You spoke about network effects. Can you elaborate?
Indeed, Your Honor. Your Honor, if we see the facts of the present case, it was stated that the Celestial had such a distribution system which the businesses in Aristam are used to expand their business throughout the country. Your Honor, that clearly established the fact that the network of the Celestial was such that it would create such an effect that it would be difficult for other new entrants to enter this relevant market and to establish such a network if we compare it to Celestial. To satisfy Your Honor's query.
Is there a theory of network effects that you want to touch on, or I mean, is it as simple as just creating a network of sellers?
Your Honor, the Council was only relying on the fact that the distribution system and the system adopted for the sellers on the platform was such that it would create such a distribution network effect that it would have a high network effect.
So, Council, I think just to add to what Mr. Gandhi just said, in terms of paragraph 8 of the proposition, can you tell us a little bit more about network effects, what you meant to say? I mean, I think the question which was raised was to understand what exactly network effects is. And do you think, is there anything in the proposition, including paragraph 8, which can assist you in describing what you mean by network effects?
Your Honor, as the paragraph, it is related to the market study conducted by Ajax Private Limited, and in that it was clearly stated that because of the fact that customers mainly preferred Celestial as a platform, it would have such, and it was has a such user friendly interface. It would have such consumer base which would term it as an entity which having a high network effect.
Anything more you want to add to what exactly you mean by network effects?
No, Your Honor, at this point,
No problem. Thank you. Please proceed.
much obliged, Your Honor. Your Honor, coming to my third submission, that buyers lack the countervailing buying power against Celestial. Your Honor, the countervailing buying power would be the result of a viable alternative. If we see the facts of the present case, in paragraph 8, it is also stated that the products on Celestial were usually discounted. Now, the point herein is, if there had to be a viable alternative, it has to counter the price offered by Celestial. Your Honor, also, if you see the end consumer in this present facts and circumstances, it is a fragmented consumers, and it is not a such one big entity which would have such economical power that would bargain with a dominant entity, that is Celestial herein. And hence, Your Honor, the council contends that there are sufficient fact herein to that the buyers lack the countervailing buying power against Celestial. Beyond.
So, Counsel, when you say countervailing buying power, you mean countervailing buying power of me and Sameer when we buy toys of Celestial? Or do you mean countervailing buying power vis-a-vis the manufacturers who are selling on Celestial?
Your Honor, the countervailing buying power related to the toys sold by manufacturers on the platform.
Okay. And can you please explain how that links to the discount and the price that you were referring to?
Your Honor, pardon?
You mentioned that there are the heavy discounts offered by Celestial. So how does the countervailing buying power relate to the discounts?
Your Honor, as it is stated in the market study, that products, if we compare it to the usual retailing, we usually discount. As we see in the normal course of e-commerce platform, that products are usually discounted on the platform. Your Honor, if consumer has to negotiate with Celestial on the price point, and as the products were usually discounted on Celestial, hence there would be no alternative supplier to Celestial which could supply at the price point offered by Celestial. If it satisfies Your Honor's query.
Any other facts in the Moot proposition which you think indicate that manufacturers did not have a countervailing buying power against Celestial?
Your Honor, it is stated in the DG report that the four toy manufacturer implemented independent algorithms to counter the discounts offered by Celestial. But even the four toy manufacturers, which held 85% of the market share, couldn't compete the discounts offered by Celestial, and hence they were forced to list themselves on Celestial for commercial gains. If this fact clears the doubt raised by Your Honor.
Yeah, you can proceed.
Much obliged, Your Honor. Your Honor, coming to my next submission, that Celestial provided an essential facility in the relevant market. Your Honor, for this, the council would like to refer to paragraph 1.22 of the written submission of the informant, wherein the case of GMR, where it has been stated, GMR Hyderabad International Airport Limited and others have been stated, wherein the Competition Commission of India has laid down the criteria which has to be considered while assessing whether an enterprise is an essential facility in that relevant market. For that, Your Honor, the council has 3 points which satisfies the fact that Celestial provided an essential facility in this relevant market. Your Honor, firstly, Celestial control access to the essential facility. Your Honor, it offered the essential facility and control access to it, and it cannot be duplicated by any competitor economically due to the size resources and the network effects generated by Celestial and its reputation. Can coming to my second point, that there was no other reasonable means to enter the market. Your Honor, herein the emphasis ought to be applied on the word reasonable. If we see the facts of the present case, the cooperatives as well as the manufacturer were forced to sell their products on Celestial for commercial gains. Hence, it can be established that there were no other viable alternative to enter this relevant market. Now, coming to my third point, that the entity denied access to the competitors. Although this issue will be dealt in detail in the next my submission, where I have delineated the fact that Celestial has abused its dominance. But herein also it is pertinent to state that the preferential treatment meted by the Celestial to preferred sellers resulted in constructive denial to market access. Hence, Your Honor, the council contends that DG has failed to appreciate all these facts to term it as a non-essential entity.
Council, I have a question on essential doctrine that you mentioned.
Yes, sir.
If Celestial was a competitor of these manufacturers, then probably it would have that incentive that, as a competitor to them, it would want to sort of foreclose the market for itself. Here, its business is sort of based on those manufacturers coming onto its platform? Why would it want to follow such a restrictive policy as you're mentioning?
Your Honor, if we see in the relevant market, the four dominant entities also created their own websites to counter Celestial and to gain commercial advantages. But even that four online websites couldn't counter the discounts offered by Celestial, and were not generating enough revenue to meet their needs, and their revenue was constantly declining. That would establish the fact that the four toy retailers, although they listed on Celestial later, but initially they were trying to counter Celestial as a platform for selling toys in this relevant market.
No, I'm talking about incentive for the platform to engage in such a foreclosure with core the suppliers on its platform.
Your Honor, if Your Honor permit, may the counsel proceed to my next submission wherein the query raised by Your Honor would be clarified. Much obliged, Your Honor. Your Honor, that will the counsel will be dealing in this issue.
Sure. In that case, before you proceed to the next and answer that question, just wanted a few thoughts from you. So, one, can you explain to us what do you mean by essential facility doctrine? What are the determinants? And number two, I understand one of the reasons why you have said that there was no other reasonable way to access this. You have again relied on para 10 because you're saying they were forced to. Do I understand the premise of your argument is it because of the pandemic they were forced to, and but for the pandemic there were options, reasonable way to access this facility if there was no pandemic?
Your Honor, pandemic was just the contributing factor, and if we see the market study in paragraph 8, and before the paragraphs also 6 and 7 and 8, it is clearly established that that they were not generating enough revenue, and because customers were mainly preferring Celestial over any other platform. Your Honor, the pandemic was just the contributing factor to the growing trend in this market.
Okay, and how about the first question, Shayas?
Sorry, Honor.
What are the determinants to say? When do you say there is facility is an essential facility?
Your Honor, as the council has stated that Competition Commission has given specific criteria to list an enterprise as a dominant entity. Your Honor, if an enterprise is termed as a dominant enterprise firm, then it cannot refuse to grant access to its platform, which is difficult to replicate, which it controls to other firms or the competitors. Your Honor. That is the Honor's query.
Council, are all dominant entities therefore providing essential facilities?
No, Your Honor. All dominant entities do not provide an essential facility, but merely all essential facility are dominant enterprises. That is, council is contending here that it is an essential facility, it can be termed as a dominant enterprise in this market.
So, council, the distinguishing factor for you is whether that facility can be replicated. Is that right? Because you mentioned that.
Indeed, Your Honor, it is one of the factors.
Okay, what are the other factors?
Your Honor, that there are no reasonable means in the facts and circumstances, and it controlled access to the market, and it would amount to abuse because it has constructively denied access to that market. So
let's leave the abuse part aside and look at the reasons for how I can say something is an essential facility. So one is it cannot be replicated. Number two is there is reasonable means. Reasonable means of what?
Reasonable means to enter the relevant market.
Okay, which is again similar to replication, right? Whether I can create that facility again. And the third factor is?
You know, that would be the abuse of that essential facility.
Okay, so then essentially we are with replication. That seems to be the central point of whether a facility is essential or not.
Yes,
right?
ma'am. Yes, ma'am.
So we know that there are other competitors of Celestial in the market because it only has a significant market share. So I'm assuming the rest of the market share is with somebody else. We also know that the 4 Ajax, Icarus, and all of those set up their own dedicated stores. So clearly it can be replicated, right? So then why do you say that Celestial is an essential facility?
Your Honor, before moving to the query raised by Your Honor, may the council be granted an extension of time?
Your Honor, I think you should certainly answer this question and then we can wrap up.
Indeed, Your Honor. Your Honor, If we talk in the context of e-commerce platform, then it would be a different story in itself. But herein, we are only concerned with the relevant market. That was the market for toy manufacturers. If we see the facts, the major market share has been shifted to Celestial. And as it has a higher customer base, it would be clearly established that it was an essential facility in this relevant market. And we're not talking in reference to as an e-commerce platform. If it satisfies your Honor's query. And if there are any concern the council may clarify on.
I think we can proceed with speaker 2 unless Samir Diksha, you have any follow-up questions.
Just one quick question and you can answer in yes or no. Can we give a finding against Celestial even if we do not find it to be an essential facility?
Yes, Your Honor, you can give, because there are other factors given in 19 clause 4 are also satisfied in this present facts and circumstances.
Okay, I think we can proceed to speaker 4.
Your Honor, should the council deal with the abuse of dominance issue, or the council should rest his case?
You can rest your case, I think.
Good, Your Honor. It was a pleasure arguing before this honorable bench.
Thank you.
This is the second speaker appearing on behalf of the informants. Am I audible?
Yes.
Yeah.
I will be dealing with the next two issues. So firstly, the council would like to point out a few facts that are extremely relevant to the next two issues. There was a meeting held in 2018 of the manufacturers that we know hold at least 85% shares in the toy market. After the meeting, they decided to strategize and implement independent price tracking algorithms on their respective websites to counter the discounts that were being offered by Celestial. In that regard, the four manufacturers implemented their own their price tracking algorithms together. And after that, when they could not seem to counter the prices that were being offered by Celestial or track the prices that were being offered by Celestial using that algorithm, and the websites were not making as many sales, they decided to abandon the algorithm and list their products together on the website that was Celestial. After which they also employed the Black Knight algorithm in this regard. Now I would be dealing with the first issue, which is whether Ajax, Icarus, Kingo Private Limited, and Spyrite are in violation of Section 3, Clause 3A of the Competition Act. The existence of an agreement is sine qua non, as mentioned in the case of tire cartel, like various other cases. The existence of an anti-competitive agreement or a practice can be inferred from the conduct of the colluding parties in absence of any plausible explanation. Firstly, when these manufacturers deployed the independent algorithms with a common intention to fix prices, and secondly, there was an explicit collusion amongst the four manufacturers when they made a concerted effort to employ the Black Knight algorithm and decided to list their products on a platform that was Celestial. Moving on. Price parallelism in general cannot be said to have an anti-competitive effect, but however, it can still be used to point out the starting point or the meeting of minds of the meeting of minds for a collusion to happen. To reasonably infer the existence of an agreement or a concerted practice, the parallel conduct is to be supplemented with a set of actions which are inconsistent with unilateral best response behavior. During the annual meet, as the council had mentioned, there was a discussion between the four manufacturers, after which they implemented the algorithm. The collusion in the meeting of minds of the four enterprises can also be inferred from the further conduct and the later conduct when they decided to abandon the independent algorithms and actually list the products on Celestial and further employ Black Knight on that platform. Which also,
Council, just one quick question there. According to you, the cartel began in which period? Which year did the cartel begin between them?
Your Honor, the cartel began in 2018 only.
And continued
Since
up.
the,
So-
yes, Your Honor.
For 2018, you're seeing that the deployment of the algorithm, even though they were independent algorithm, that is that amounts to collusion.
Your Honor, the council would like to point out that the chain and the circumstantial evidences, the chain of events that happened over a period of time, there was a tacit collusion from the period of 2018 to 2020. And from 2020 onwards, when they listed their products on Celestial, there was an explicit collusion since they entered into an agreement.
So in 2018, what act exactly of the four toy manufacturers you are alluding to be as a cartelized act? What was that activity? Can you please tell us precisely?
Your Honor, the price parallelism that was maintained in this regard because of the price tracking algorithm that they had employed was a very anti-competitive practice in this regard, and they further perpetuated the cartel and the activities of the cartel even on a platform like Celestial, as the council has pointed out. And they've started to provide uniform discounting since they were just trying to counter the prices that were being offered by this one platform. There was a huge price parallelism and uniform discounting that was maintained on all their platforms without any competitive strategy for that matter. Sorry
to intervene. Let me just break it down for you. Three events. In that period in 2018, the four companies independently decided that they will open their online store. They did open. So act number one, they opened their online store. They independently decided they will employ a price tracking algorithm. They independently did it. Number third is that due to that price tracking algorithm, the prices which came up on their individual retail stores, I mean online stores, sorry, they were similar price because they were tracking each other's pricing. Out of these three events, which one you wanted to say is a cartelization?
Your Honor, the council would firstly like to point out that the decision of implementing the price tracking algorithm also was not independent. In fact,
can you take us to the exact paragraph of the Moot proposition where you are relying on? This is a factual issue to tell us that it's not independent.
Sure, Your Honor. Your Honor, the DG's report had mentioned about how Mr. Harrington had given this annual speech, following which this had happened in paragraph.
Which can you just tell us? Paragraph 10.
Paragraph 19. 19(4) A, B points point out the similar facts. On page number 6 of the Moot proposition.
Okay. Carry on.
If Your Honor permits, may the council proceed?
So yeah, respond to the question which I asked. So go ahead.
Your Honor, so the council would like to point out that the collusion and the collusion had started from the very beginning after this, after the annual meet, after which the different manufacturers actually implemented the algorithm. They were trying to track this one, mostly the most important player in this regard, which was the prices that were being offered by major sellers like Celestial in that regard. They started to offer uniform discounting so as to counter this one entity in the relevant market. The strategy that they employed was not to track, actually bring down on prices on any competitive basis, but to just counter the prices so as to actually, counter the prices that were being offered by Celestial. The price parallelism in the market was being maintained, and which also led to creating an anti-competitive and an unfair environment in the market.
So, Council, all I can see from these two A and B sub-paragraphs is that there was a unilateral call by one gentleman from one of the companies, and then we see that there was some parallelism in price. Would that amount to cartelization in terms of Section 3 in your view?
Your Honor, the Council would like to point out that Section 3 also includes the tacit agreements in this regard. As Your Honor pointed out
How
that,
do you claim there was a tacit agreement here?
Your Honor, the further acts and the later conduct in para 10 that has been mentioned also is very evident of the fact that there was a certain collusion that existed from the very beginning when the four manufacturers
So
decided to collude in the
I would
cartel.
like to take those on whenever you are arguing those, so that we sort of look at the holistic, series of events and then figure out whether they were sort of interrelated or not.
Definitely, Your Honor. The Council would be glad to discuss this issue further with you. Moving on.
Sorry, Council, just to not to push a point beyond existence, but when you say price parallelism is indication of collusion, it speaks to the existence of an agreement, right? Which is the first part of Section 3, subclause 3, subclause A. Right? Could you let us know whether mere price parallelism, because of course prices can work in parallel absent an agreement as well, right? I mean, you could have the price of umbrellas could all be the same. Cost of production could be the same, so on and so forth. So could you just explain as to why the price parallelism, whether it is tacit or actual collusion, is indicative of collusion?
Your Honor, the Council would like to point out that price parallelism could be taken as a starting point to see the meeting of minds in this regard. The actions that pursue after that the four manufacturers actually did, make this contention of the council actually stronger in this regard, which is why the further conduct and the later conduct of how they explicitly colluded together while employing the Black Knight algorithm also shows that there was a certain understanding that was there, a certain agreement that was there, even if it was tacit back then.
Seems like you're suggesting that it's the Black Knight algorithm which actually may have strengthened your hands in terms of actual evidence of collusion. But you seem to have a primary level argument which suggests that even without the Black Knight algorithm, there is indication of cartelization, which I'm not seeing from the facts that you're laying out. But why don't you go ahead?
Sure, Your Honor. The council hopes that the council can prove the point that Your Honor is requesting for in the course of the next few arguments. The council would now like to move on to the point of the hub and spoke model and how Black Knight was actually acting as a hub and the four manufacturers were the spokes of the model. A hub and spoke arrangement is exchange of sensitive information between competitors through a third party that facilitates the cartelistic behavior of such competitors. In the present case, the Black Knight's model is a hub and spoke model, wherein the spokes are the four manufacturers and the hub is Black Knight. Black Knight was used to exchange for the exchange of sensitive information, including information on prices, which facilitated price fixing. There's an explicit collusion amongst the manufacturers, which substantiates the point that there was clear conspiracy to fix prices. Further, the acts of the case at hand satisfies the determining factors of the hubs and spokes model as laid down in the aforementioned case, which is the Samir case. The Samir Agarwal case versus CCI also talked about the hub and spoke model in this regard. In that regard, there was big data that was taken into account. Big data like factors like timing of the cabs, since it was a cab, Ola cab or Uber cab case. The major factors that the apps took into account were the timing of the cabs, the area that the person was traveling to, based on which it computed prices. And it was said that it was based on competitive characteristics and a competitive strategy, which in this case was totally absent, since the algorithm merely put discounts on the products of one of the four manufacturers for a period of 2 months on a rotational basis, and did not take into account any of the competitive strategies in this regard. Moving on, the council would like to talk about how there was adverse appreciable effect on the competition in the relevant market. Section 19, clause 3 of the Act mentions 3 negative and 3 positive factors that need to be satisfied to prove whether there was AEEC or not. Firstly, the
Sorry,
council
Council,
would
just to interrupt you for a moment. I'm mindful that you have limited time. Do you need to prove AEC if you establish that there is a cartel?
sorry, Your Lordship, the council.
Do you need to actually prove AEC if you've established that there is a cartel?
Your Lordship, yes, the presumption is there on the other side, but we would like to say the effects of how the cartel actually functioned and caused the adverse appreciable effect in our case. If Your Honor.
Okay, go ahead.
Your Honor, the council
Samir,
would
you had a
now.
follow-up question? Sorry, Samir, you had a follow-up question? Okay.
Okay, then I have a quick follow-up question. Where, in whose favor does the presumption lie? You mentioned that the presumption is on the other side. So how does the presumption operate? Could you just elaborate on that?
Your Honor, the presumption lies on the side of us, like the informant, since we're making the allegations, Section 3, Clause 3. So we would like to clarify on this regard as well. Your Honor, now the council would like to point out the adverse appreciable effects that were caused during the period of 2018 to 2020, when they had employed independent algorithms on their independent respective websites. From 2020 to 2018 to 2020, the companies agreed and started using their individual algorithms on their respective online websites, wherein they entered into an understanding. The new entrants who would not have to actually compete with all the major companies would now have to take into consideration of all of its major competitors. Since it eventually made it impossible for the other sellers that were already existing in the market with a much smaller market share to survive. Similarly, it also
just interrupting you there for a minute. Celestial was still offering huge discounts, and in fact, these people abandoned the algorithms because Celestial was still offering huge discounts, right? So anybody who was entering the market could have easily sold products on Celestial where they would be discounted. So why do you say that the price tracking or the parallelism in their pricing had any AEC in the market? As consumers, I could still get discounted products, and the remaining manufacturers could still sell on Celestial.
Your Honor, the council would like to point out here that as consumers and to maintain a fair market as well, the importance of competitors in this regard is extremely huge. AAEC is also assessed based on sellers and on consumers, the effect that these four companies colluding together, which if they hadn't, would have been competing against each other, considering that they are the four companies that form the 85% and the four companies that are of the organized sector of the toy market would have been competing against each other, and which would have actually led to betterment in production, sales, or distribution of services of toys in this regard. So in this way, it also affects the sellers, while it also affects the consumers or the manufacturers in this regard.
Council, I think the question was that because Celestial as a trade channel was already open, and the facts do say that people were preferencing Celestial because it was easy to buy and all of that. The question which came from the learned was that why do you see there was any anti-competitive effect at all? So can you respond to this question on facts of the case? Do you have anything from the facts where you can respond to this question?
Your Honor, in the present case, the council would like to point out that when they listed even their products in Celestial as well, there was preferential listing that was happening in this particular regard. The Celestial was providing a preferential listing services to the four manufacturers and also facilitating the cartel. There was also a search bias that was created as it is mentioned in the paragraph 14 of the Moot proposition. It clearly says that even when any of the users put any of the search put anything for the search results in the toy category, the more expensive products of the toy manufacturers would actually be shown way over than the products of the smaller cooperatives in this regard. the council would like to point out that these complementary factors also led to creating an anti-competitive environment in this regard.
Okay, I have no follow-up questions.
Only maybe just to ask, which is that, do you think the consumer, the end consumer, was better off or worse off as a result of all of this? If you looked at, for example, the price of a particular product as a result of the heavy discounting scene, possible that he was getting it or she was getting it cheaper as a result of this. So where is there real tangible end consumer harm if price was a factor? Or are you looking beyond price?
Your Honor, I would like to point out that even from a consumer perspective, the pricing, the quality, the services that the companies provide right now, it might not seem like a big issue in this regard, but eventually when the market opens up and the market functions in a way that whenever there is a competitor, or to maintain a fair ground, the companies make efforts to either improve on their product, improve on their services, improve on their prices, which actually benefits the end consumers as well in this regard. Can the council now proceed with the next issue?
Please.
Much obliged, Your Honor. The council would now like to discuss the issue of whether Black Knight and Celestial have facilitated the cartel between the four enterprises in violation of Section 3, Clause 3 of the Competition Act. Firstly, the anti-competitive agreement between the facilitator and the cartel comes under the ambit of prohibited agreement under Section 3, Clause 3 of the Act. Secondly, that Celestial had the intent and an active role in facilitating the cartel. And thirdly, that Black Knight had actively contributed to facilitating the cartel and its activities. On a bare reading of Section 3, Clause 3 of the Act, there is no explicit mention of the term facilitation in the statute, but a comprehensive reading of this section will actually imply that any kind of anti-competitive agreement which affects the competition in the common market can be prohibited under Section 3, Clause 3 of the Act. In the case of AC Truant, the Commission had, Your Honor, you had something to say?
Yeah, I was actually going to ask you if there's any legal authority which says that facilitators can be found to be liable.
Your Honor, the Council would like to point out to the case of AC Truant, in which the Commission pointed out that to prevent the creation of new forms of collusion with the assistance of undertakings. It's been mentioned in para 3.5 of the submission that the council has submitted. To prevent the creation of new forms of collusion with the assistance of undertakings, which are not active on the markets concerned by the restriction of competition, with the aim of circumventing the prohibition laid down in Article 81, Clause 1 of the EC Treaty. The aforesaid rationale needs to be applied in the present scenario so as to prevent the creation of new forms of
Yes, Your Honor. Anything closer to home? Is there anything that the CCI, for instance, has said about facilitators?
Your Honor, the council is, since the statute is not actually inclusive of facilitating as an example, the CCI has not included anything per se that would be very, very relevant or very, very parallel to our case. So the council is not, the council doesn't think there has been any sort of suggestion like that by the CCI as of yet.
Okay, so forget about any precedents with the CCI. Does your statute allow you to argue that facilitators in the current form could be argued to be within 3.3? How can you sort of elaborate on that aspect?
Yes, Your Honor. In the current scenario, the statute under 3.3 does not per se include any word which would include facilitation, but Section 3.1 has been interpreted as an umbrella clause which would cover all the agreements, all the anti-competitive agreements which are likely to have an effect to cause AAEC as mentioned under 19 Clause 3 of the Act. So the council would like to assert.
So to be clear, you are arguing 3.1 here and not 3.3, right?
Your Honor, the council is arguing 3-3 since the allegations have been made under 3-3 of the Act.
No, but
the
how do you argue? How do you argue that Black Knight and Celestial are in identical business as these toy manufacturers?
Your Honor, in the present case, the council would like to say that that on a conjoined reading of section 3.1 and 3.3, both the parties could be made liable under the Act.
Therefore, if there is a vertical agreement, which 3.1 obviously being an umbrella provision, a vertical agreement clearly falls under 3.1 as well. So what you were suggesting, we can argue that under 3.1 read with 3.3 as well. Because your suggestion is that anything which can be read with, which can sort of come under the ambit of 3.1 can be read along with 3.3 to argue infringement.
Your Honor, the council's time is over. May the council have an extension to answer your question and move ahead?
Yes, please.
Your Honor, the council would like to point out that since 3.1 and 3.3, since 3.1 is an umbrella clause which would cover 3.3, and 3.4 talks about different stages of production chain. So the council would like to suggest that 3.1 would actually include 3.3, and the application in this case would be of 3.3 and 3.1.
So sorry, I mean, I think we'll have to wind up this, but before just what Pranjal just asked, can you give us an answer in yes or no? Is our understanding correct? But for section 3.1, had there been no section 3.1, it is your position, and in this case, you could not have argued for a violation of 3.3a, right? It is only because there is a 3.1 that you are able to argue. Without 3.1, with the current language of 3.3a, in this case, you would not have made an argument on violation of 3.3a against Celestial and Black Knight. Is that your correct position? Can you answer in yes or no?
Your Honor, that is right. But the intent of the Act in this regard, the council would like to actually point out the intent of the Act in this regard. Like the council mentioned the case of AC Truand and Article 81, Clause 1 of the EC Treaty. The intent of both the acts is very, very similar, and a clear parallel can be drawn between the intent of Article 3, Clause 3 and 81, Clause 1 in this regard, so as to maintain a fair competition. So the council would like to suggest that the acts of facilitation could also come under the ambit of 3, Clause 3 in this regard.
Okay, I have no follow-up questions unless anyone else has. Do you want to continue with this, or should we, given the time is up, should we go ahead with respondents? Samir, Diksha, Pranjal?
Yeah, I think we can wrap up.
Yes.
I agree. Let's wrap up.
Okay.
It was a pleasure to plead
What
before
are
the
your
commission.
prayers before we end? Very quickly, what are your prayers?
In the lights of the facts of the case, arguments advanced, issues raised, and authorities cited, may this commission be pleased to adjudge and declare that first, Celestial is a dominant enterprise and was providing an essential facility in the relevant marketplace. It has also abused its dominant position, which are in violation of Section 2 Clause A, 2 Clause C, and 2 Clause E of the Act. Secondly, the four enterprises had entered into an agreement which had an adverse appreciable effect on the competition. Thirdly, the acts of the four enterprises are in violation of Section 3, Clause 3A of the Act, since they had an anti-competitive effect on the competition. Fourthly, that Black Knight and Celestial have facilitated the cartelization between the four manufacturers. And lastly, the acts of Black Knight and Celestial are in violation of Section 3, Clause 3 of the Act.
So other than declaratory relief, do you want anything else from us? Do you want us to give money to anyone, pass any other directions? Can we do that?
Your Honor, you can, the court can definitely grant some relief to the aggrieved party under Section 27 of the Act.
To the aggrieved party, as in the people you're representing, which should be Star Fox and an anonymous guy.
Yes, Your Honor.
Okay, we can pay them money under Section 27.
Your Honor, the council would like to not, you could penalize the other party in this regard, not pay the money, in fact, but a penalization of the acts that have been causing the market disruption should definitely be there.
Okay, anything else you want us to do?
No, Your Lord, no, Your Honor. Thank you so much.
Thank you. Should we move along?
Counsel for the opposite parties, I seek permission to address the bench. Greetings to the respected members of the commission. The council seeks permission to address the bench collectively as Your Honor. Much obliged. Your Honor, at the this is council number 1 appearing for the opposite parties. At the outset, the council for the opposite parties would like to state that insofar as the conclusions of the DG report are concerned, with respect to the fact that Celestial is not in a dominant position and has not abused such position, we are in full agreement. The council would first like to address the argument that was raised by the learned co-counsel for the applicants, stating that the online market, or the market that Celestial is a player in this case, constitutes a separate relevant market from offline retail chains. For this, the council would like to place reliance on the Ashish Ahuja versus Snapdeal case of 2014, where the Competition Commission of India very clearly stated that even though different market conditions exist, and even though that there are differences in terms of options available, in terms of price, in terms of the shopping experience, at the end of the day, consumers do weigh in options both offline and online. And in case prices do go up significantly online, they walk to the retail store and make an informed decision, and vice versa. So therefore, the commission clearly held that what online and offline channels or markets are merely distribution channels of the same product, and they cannot be held to be two separate relevant markets.
Counsel, I think you argued against yourself when you said Ashish Ahuja is a 2014 case. So, closer to now, ever since the pandemic, how does that argument stand good?
Please, Your Honor. Your Honor, insofar as the pandemic is concerned, now the customers that Celestial has are divided into two classes. We have the customers who make purchases on the platform, as well as the retailers and manufacturers who sell their products on the platform. Now, the shift in consumer preference has been happening according to paragraph 5 of the Moot proposition since 2019. However, it has been significantly exacerbated by the COVID-19 crisis, which can be seen in paragraph 9. Due to the prevailing circumstances that have in the economy, and in addition, because of the lockdowns and the repercussions that it has in business, there has been a certain impact on businesses, which has led them to become more reliant on online channels. But that does not by itself mean that online channels constitute a separate relevant market. In fact, Your Honor, in paragraph 6, the preference for in-store shopping is very clearly laid out. In fact, customers and their children, who are the target audience for the toy market narration, prefer walking into stores and physically checking out the products available on display and then making purchases. So merely because certain circumstances have changed due to the COVID-19 pandemic, a mere shift in consumer behavior of a transient nature is not sufficient for us to conclude that it constitutes a separate relevant market as a whole, Your Honor. Now, if Your Honor is satisfied with the response,
I think you argued that nature of product, and I think you mentioned that in-shop experience is important in these kind of products. Probably, can you elaborate on that? Can that change the delineation of the market?
No, Your Honor. Your Honor, the point that the council was trying to make is that both offline and online channels are substitutable in this case. Now, the key criteria to determine the relevant product market would be substitutability and interchangeability. And since individuals are not, the only option that they have is not online channels, since they can also access retail chains and offline stores, both of them would fall into the same relevant market. And the online market or the e-commerce market would not become a separate relevant market, merely on account of prevailing circumstances of a transient nature.
But as I understand, toys are also sort of very commoditized and not really differentiated, as opposed to a vehicle where you need to experience and have the touch and feel sort of touch and feel is very important in those cases. Why would toys be relevant to be considered, to be experienced in store?
Your Honor, the Moot proposition paragraph 6 clearly states that since the target audience is children, the main target audience for toys is our children, and therefore it is clearly stated that it's the preference of parents as well as children to go to these stores and let their children pick out the toys that they are most attracted to. And the argument that is being made is that even till up to 2019, the significant chunk of revenues of all these toy manufacturers came from their retail stores, which again can be found in paragraph 7 and 8 of the Moot proposition, Your Honor. The significant chunk of revenues did come from offline channels, and it is because of the COVID pandemic, there has been a transient shift, yes, but that is not sufficient to completely delineate or carve out a separate relevant market for e-commerce channels.
Please go ahead.
Please, Your Honor.
Sorry, not to push it further. Few questions. You mentioned that it's a transient shift. You do agree that there is a shift which has happened effective from March 2020 when the global pandemic hit, right?
Please.
Okay. So you would agree that the whole concept of relevant market is also related to time. We don't define relevant market in eternity. It's all dynamic concept, right? The allegations against Celestial, much of the allegations against Celestial are post 2020. Would you agree that post 2020, given the consumer preference, nobody wants to go to, I mean, I would not like to go with my child into a retail store and buy a product there because there are serious health risks. So normally people are doing everything online. So post March 2020, do you agree that given the consumer preference, which of course is one of the factors under the Act as well to determine relevant market, the online and offline cannot be said to be substitutable, and therefore online market can be segmented as a separate market?
No, Your Honor. Much obliged. Your Honor, in terms of whether an online market can constitute a separate relevant market, the key principle again is substitutability, and it is submitted that as of now, as clear in point number 3 of the clarifications, that businesses are reopening and businesses are allowed to function, although with certain restrictions. The key criteria becomes whether or not the consumer has access to the market, and whether the consumer, if price fluctuation does happen, and if the terms on or the prices on an e-commerce platform become too high or exploitative, they can decide to walk into an offline store. So they do have the reasonable substitute to make purchases on an offline medium as well. And that is the contention of the council, Your Honor.
So you're saying mere theoretical access is sufficient, even if practically it may not be possible for someone to access an alternate source, alternate trading channel. The mere theoretical access on paper is sufficient for determining substitutability?
No, Your Honor. The council does not submit that it's mere theoretical. It submits that access does exist, and yes, certain consumer preferences do need to be taken into consideration while ascertaining the relevant market. But in this case, the contention is that it is insufficient. The evidence at hand is insufficient to state that the online market should be carved out as a separate relevant market, since these businesses are reopening, and especially considering that pre-2020, a large chunk of their revenue did come from these offline markets, and consumer preference, as stated in paragraph 6, was always leaning towards the offline mode of transactions. They always did prefer to walk into offline stores and make their purchases.
Okay, one last question on relevant market. Would geographic factors and access to e-commerce websites itself, would that be also a factor in determining the relevant geographic market? So what I'm trying to ask is that would the access to e-commerce as a trade channel, does that have to be uniform across India to find it as a relevant geographic market, whole of India as a relevant geographic market?
Please, Your Honor, as far as the relevant geographic market is concerned in this case, since the platform is accessible pan-Arisham, then yes, since the geographical market remains Arisham. And again, it remains whenever retailers and manufacturers have access to the platform to place their products, to reach out to consumers across, and where the products are homogeneous, more like. So within the boundaries of Arisham, yes, that remains a relevant geographical market.
Please proceed from my side. Go ahead.
Much obliged, Your Honor. Your Honor, insofar as the dominance of the of Celestial in the relevant market is concerned, the Learned Counsel for the applicants have placed a lot of reliance on the significant market share as well as the popularity of Celestial in the market. First and foremost, Your Honor, the council would like to state that there is no conclusive numbers insofar as the market share is concerned. The words used is significant market share. And another key aspect, which is the market share of the other players in the market, is also something that we are not privy to. However, the council would like to place reliance on the Raghavan Committee report, which was a very important precursor to the Competition Act, which was enacted in India in 2002. This can be found in paragraph 8 of the memorial written submissions. It very clearly stated that the current market share, although important, is an insufficient prerequisite for dominance. In fact, the committee report goes on to say that there are other factors that may play a huge role in inhibiting or constraining the behavior of a firm in a market. And two of those examples include the lack of barriers to entry, and there's a possibility of potential competition, Your Honor. Your Honor, in this case, as very clear from paragraph 8 of the proposition, Celestial is not the only e-commerce platform in Arisha. There are other e-commerce platforms that are in competition with Arisha. And neither is Celestial the only way, only means by which manufacturers and retailers can reach out to customers and sell their products. Additionally, Your Honor, in so far as there are barriers to entry, Celestial has in no way affected to the detriment competition in the market, because there are no significant barriers to entry. As far as the popularity of Celestial is concerned, it is a result of insistence on quality and good customer experience, which again is provided in the proposition itself in paragraph 8. So yes, Celestial is incredibly popular. Yes, people do prefer Celestial over other e-commerce platforms, but that can be attributed to the success of the enterprise as a whole. And to say that that success in itself is enough sufficient when the market is generally contestable, because firms are free to enter the market, they're free to make investments, they are free to compete with Celestial. In fact, competition does exist. And as the DG report has concluded, there is significant competition.
Sorry, Counsel, we understand your argument. I think the Counsel for the informants, they argued network effects. Now, how do you counter that?
Insofar as the network effects and the Celestial does enjoy certain commercial advantages, but again, that are a result of the business acumen and of the success that it has achieved by offering good quality services. So the point that the council was trying to make is that Celestial must not be punished for its success. In terms of the willful acquisition or maintenance of market power, there is not enough factual evidence to prove that Celestial is in any way acted to retain such market power or to even exercise that market power to the detriment of competition.
No,
Your Honor.
Sorry, somebody said. No, you said that there is no barriers, but isn't time would be a great barrier in creating network effects, even if I have access to capital? How do I do that? And how?
Your Honor, time certainly would be a barrier. Time wouldn't be a barrier to entry. Time would be one of the challenges that certain firms would face in terms of investment and in terms of other considerations that would go into actually competing with a successful enterprise like Celestial. But that by itself would not amount to a sufficient entry barrier, because the market still remains contestable. And the fact that consumers can still very easily opt, if Celestial's prices are not fair or Celestial prices are too high, consumers can still easily opt for another e-commerce platform or for another dedicated website of another toy retailer, or they can hop over to a retail store. So the options are still there. And Celestial is therefore constrained by this consumer choice. Celestial is constrained by the fact that competition not only does exist, but also potentially can increase. And that is a submission that the council was trying to make, Your Honor.
So the informants argued that the 4 toy manufacturers exclusively shifted to Celestial, and that's where they were offering their products. So why would that be the case if you were not in a dominant position?
So, Your Honor, once again, the fact that Celestial is appealing and is popular in the market has been proven in terms of the wide range of products that we have offered, in terms of the discounts, in terms of the user friendliness. Yes, there is a consumer preference, and there are a lot of other factors that have attributed to Celestial being so popular. Insofar as the failure of the other manufacturers to sustain their own independent websites, it can be attributed to several market factors and cannot be safely concluded it is merely because of the dominance of Celestial. Because possibilities of competition did exist, and they did have the opportunity to push their products to that channel. And if consumers so wished, they could access that platform and they could make purchases through that platform as well. And it's only because
we are not attributing intentions here, that whether you have sort of participated or played a role in others not assuming that position, but dominance is a assessment of the state of the market. We are not casting any aspersions on your role in keeping others out of the market, but as a matter of fact and as a state of the market, do you believe that you are in a dominant position? That's the question.
No, Your Honor. Your Honor, given the existence of other competitors in the form of other e-commerce platforms, given the fact that consumers have so many different means to purchase products from the same market, we do not believe that Celestial is in a dominant position. However, Your Honor, if Your Honor allows, the council would like to submit that mere dominance again would not amount to abuse. And for this, the council would like to place reliance once again on paragraph 4.4 of the Raghavan Committee report, where the words willful acquisition and maintenance of market power has been used. So it is when there is a willful acquisition and maintenance of significant market power with the idea to reserve competition to one side or to restrict competition in the market, that is where abuse can be brought in. And the learned counsel for the applicants have argued that by virtue of the agreement between the four manufacturers and Celestial, which has, they have argued that it has resulted in discriminatory treatment against them merely based on the fact that there has been preferential product placement, to use the words that have been stated by the applicants. Your Honor, as far as paragraph 12 of the Moot proposition is concerned, in very clear terms, it has been stated that it is a complex algorithm that takes into consideration a variety of factors, two of which have been provided to us, that is user ratings and prices. And as far as the 5% commission that is charged, it is explicitly been stated that those are for services and assistance to be provided to maintain and help them improve the user ratings on the platform. To directly attribute the 5% commission to product placement, which again is a consequence of an algorithm which is applied uniformly to all retailers and to all products, would be incorrect, Your Honor. Your Honor, moreover, one of the
that argument is contested on facts, right? The DG holds something different. DG says that you have facilitated cartelization between the four toy manufacturers to display at the top of the search results on its platform for a consideration. It's not just user rating and other factors. Basically, you have agreed that I will continue to display it at top, provided you continue to give me 20% instead of 15%. That's what DG has concluded.
Your Honor, insofar as the DG report's conclusions on the issues of cartelization, my co-counsel will be rejecting all those claims. And insofar as the 5% additional commission has been charged, has been directly linked to the product placement, we deny those charges as well. The specific services that were being provided to these four manufacturers were to help them improve customer satisfaction on the platform, which thereby results in improved user ratings. And this can be found on paragraph 12 of the Moot proposition. So specific assistance has been given over and above mere product placement. So this has nothing to do with them listing their products on Celestial. After listing, we are providing them certain assistance to make sure that they perform up to consumer expectations. And this can be in the form of, just for example, Your Honor, it could be in the form of helping them tweak their listings, better pictures, better product descriptions. That it does not necessarily mean that in no way can it be concluded that Celestial is directly tweaking or Celestial has anything to do with product placement merely because of the 5% additional commission that is being charged.
Also, two quick questions here. Number one, what Parth asked, there is a finding that you have actually given preferential treatment. So I don't think we can leave that for your co-counsel to address. So for your purposes, let's assume that the DG finding is correct. If it is correct, can you please explain to us how that is not an abuse of dominance?
Please, Your Honor. Your Honor, insofar as the denial of market access, insofar as the equal treatment has not been given to Star Fox, the council would like to state that there is a right to free trade and right to enter into agreements as long as there is no intention to detrimentally affect competition in the market. And for this, the council would like to rely on one verdict of the United States Supreme Court in US versus Colgate.
Sorry, I'll have to stop here. You said there is this whole idea of free enterprise unless there is an intention to do something anti-competitive. Where from we are getting it, except this US judgment which you are going to cite, this intention? Can you cite laws from Addison?
Apologies, Your Honor, no. But since this Honorable Commission places verdicts from the US in high regard as well, which is why this submission with respect to the right to free trade has been relied on by the Council.
Okay, please proceed. Yeah.
Sorry, just to add to that, which is that is there a statutory basis which suggests that for once there is an established position of dominance, and thereafter arguably there is discrimination in the form of preferencing some and not the others, that there is any way in which you can defend your actions? In other words, is it not enough just to demonstrate those two things, or do you need to test for an appreciable adverse effect on competition? So what's the statutory position on that?
Your Honor, as far as Section 42A deals with abuse of dominance in terms of discriminatory conditions, what the Council is trying to submit is the standard to say that the act was discriminatory in itself is not fulfilled, because even by no ways is the Council conceding that Celestial has denied any sort of services to Starfox. As paragraph 15 clearly states, all that Starfox Cooperative did was approach Celestial and say, they allege Celestial of preferential treatment and said, please treat us equally. In no terms has it been clearly stated that they requested additional services and we have denied it. But what the Council was attempting to say that even if such denial was made in the first place, there is a certain, the entire objective of abuse of dominance would be to prevent a detrimental effect on competition. And when there exists no intention to push out other competitors, and there exists no intention to participate in anti-competitive activities, there does exist a freedom to trade and freedom to enter into agreements and agreements as a private entity deems fit. That was the submission that was being made.
Also, who are your competitors in this case? Who do you consider as your competitors?
As far as according to the delineation of the relevant market, Your Honor, our competitors would be other e-commerce platforms as well as all other retailers or all other entities in the market who are providing services through which manufacturers may sell their toys in the market. Your Honor, the Council has noted that the time is elapsed. The Council requests just one additional minute to wrap up arguments with respect to the essential facilities doctrine.
I think you should respond to the question which I think you're citing a US case on intention. Maybe you can do that and then wrap up on essential facility.
Please, Your Honor. So, Your Honor, the primary submission that the Council was trying to make is that as insofar as Starfox Cooperative's products have been listed on the platform, consumers, if they do so please and are not satisfied with the first listings on the first few pages, are free to access the subsequent pages. They're free to access the products of the cooperative, and they're free to make informed decisions. So there is an assumption here that no customer goes beyond the first few pages. There's an assumption here that Celestial is somehow pushing the products of the first four manufacturers, which in our opinion is incorrect, because if customers do wish to, if customers are not pleased with what is being offered to them, not only do they have additional external avenues to buy these products, they can also just click on next page and they have a wide range of products that they can list, even belonging to the Starfox Cooperative. Finally, Your Honor, the learned counsel for the applicants have stated that the essential facilities doctrine must be invoked. Insofar as this is concerned, Your Honor, the three criteria that may be proven is that firstly, the dominant party must provide the essential facility and must itself use it in detriment of competition in the market, which is not fulfilled, Your Honor. In this case, Celestial is not, as an e-commerce platform, is not directly involved in the buying and selling of toys. Celestial, in fact, does not compete with these toy manufacturers at all. If more toys are sold on the Celestial platform, the more revenue that Celestial makes. So to conclude that Celestial is using its own platform to the detriment of competition or to discourage Starfox Cooperative from selling their products in Celestial is hence not maintainable. As far as the essentials were concerned, the case that was relied on for this was a European Court of Justice verdict, Sea Containers of Stena Sealing, 1993, that can be found on page 28 of the memorial, Your Honor.
Anything closer to home where we have been told what the ingredients are for showing that it's an essential facility?
Please, Your Honor. Your Honor, in 2012, the Competition Commission of India in Arshia Railway Infrastructure versus Ministry of Railways dealt with the essential facilities doctrine, and they also laid down several conditions that would have to be fulfilled in case the doctrine has to be invoked, which would be the technical feasibility possibility of replicating the facility, the distinct possibility of lack of effective competition, and the possibility of access on reasonable terms. It is contested here, Your Honor.
That's fine. That's okay, Counsel. I'm aware you're over. Time is over. Just one last question. Can you answer in yes or no? Do you consider these toy manufacturers to be your competitors or not? Because you just said that Celestial is not competing with any of them.
Insofar as the relevant market is concerned, yes. Insofar as we are not retailers of toys, no.
Okay, I'm a little confused. You need to take one position. So please tell me in yes or no. You have to find a relevant market. Who are your competitors in those relevant markets?
In the relevant market, yes. The toy retailers are the toy retailers who provide their own services. Insofar as to sell toys are concerned, yes, they are a competitor.
They are your competitors.
But Celestial is not a retailer. That was the point. That
understood. Okay, thank you.
Much obliged.
Just before you wrap up, one last question. You did mention about this whole freedom of enterprise, that you have a degree of freedom where you can negotiate, enter into contract or not into contracts. I just wanted to understand from you in terms of competition law, whether this degree of freedom of trade, is it same for dominant and non-dominant entities, or is there any differentiation?
Your Honor, it is conceded that for dominant enterprises, there is a certain responsibility that exists to not partake in anti-competitive activities. So
I get that. And the point which you made, that the essential facility, not only it has to be used by the dominant entity itself. Can you give us case law anywhere from the globe for this position?
Yes, Your Honor. Your Honor, C Containers versus Stena Sealing, which was a 1993 verdict of the ECJ, European Court of Justice. It can be found on page 28 of the memorial submissions.
Anything from the US?
No, Your Honor.
Aspensky?
No. The case that was relied on was this, insofar as the submissions that were presented were concerned.
Thank you.
Much obliged. It was an honor arguing before this commission.
Thank you. Should we move to the next speaker?
Greetings, Your Honors. Before I begin my submissions, just clarifying if I'm audible and visible clearly. Much obliged. Your Honor, I appear as counsel number 2 on behalf of the opposite parties in today's proceedings, and the counsel would be addressing the issues pertaining to the alleged cartelization, as well as with regard to the alleged facilitation of cartelization that has transpired in Aresham. However, before delving into the substantive submissions to be made before this commission today, at the very outset, the council would like to specifically highlight that with the onset of the COVID-19 pandemic, businesses across Aresham have been severely impacted. In addition to the general apprehension of consumers to go physically to the stores to buy products, the imposition of indefinite lockdowns have restrained the ability of firms and businesses to sustain in this market. Additionally, as clarification 3 to the problem indicates, the lockdowns were implemented every time that there was a surge of COVID-19 cases, leading to a marketplace of much uncertainty for the manufacturers in this region. For businesses, especially such as that of the toy manufacturers who comprise the opposite parties in the present case, this was a particularly detrimental issue, considering the reliance on physical brick and mortar stores to sell the products, as is evidenced by paragraph 6 of the Moot proposition, leading to a further dwindling of sales by these entities. In light of the same, certain steps have been taken by the opposite party toy manufacturers in a desperate bid for survival, and these very measures are have been questioned for being anti-competitive before this honorable commission today. With regard to the second issue before this commission, it is humbly submitted that Ajax Private Limited, Icarus Private Limited, Spirite Private Limited, and Kingo Private Limited have firstly not formed a cartel, and secondly have not acted in contravention of section 33A of the Competition Act. With regard to this submission, Your Honors, it is our contention that the definition of a cartel is explicitly mentioned in section 2C of the Competition Act. And in light of the same, 3 essentials can be derived from this definition. The first being the presence of an agreement. The second being that the agreement is one between producers, sellers, distributors, traders, and service providers. And thirdly, that the agreement must control or attempt to control production, distribution, sale, or the price of goods and services. Although an agreement is quite loosely defined in terms of section 2B of the Competition Act, that is to say, it provides that the agreement need not be formal or in writing, there are certain precedents that shed light with respect to the determination of an agreement in the realm of cartelization in the region. The Competition Commission of India, particularly in the case of Indre Sugar Mills case, a 2011 judgment, had opined that in order to prove an agreement for cartelization is present, there must be an agreement for concerted actions. Such actions must be implemented, and there must be a meeting of minds in this regard. This would be an important element for this commission to take note of when determining whether or not an agreement subsists between the four toy manufacturers in this case. And the same can be found at page number 50 of the compendium that has been submitted. In regard to this, we'd also like to point out the cases of INRE alleged cartelization by steel producers, a 2008 CCI judgment, as well as the All India Tire Dealers Federation case of 2013, wherein it was explicitly noticed that price parallelism alone would be insufficient evidence of cartelization. Certain plus factors would be necessary. In light of the same, it is the contention that although price parallelism may be seen in the present matter, the additional plus factors that are required to constitute a cartel are missing in this particular case, thereby rendering the alleged agreement not to be one of towards cartelization. With regard to this, the council would first like to proceed to dispute with respect to the finding of the Office of the Director General that a cartel has been in place since 2018 between the toy manufacturers. And the same, the council would like to do the same in light of the decision of the Delhi High Court in the Great Eastern Energy Corporation Limited case, wherein it was held that the CCI cannot be bound by the Director General's observations, since there's no provision in the Competition Act which says that they have to be explicitly governed by the same. In light of the same, the evidence that the Director General report relies upon with respect to claiming that since 2018 itself a cartel had been in place can be found on paragraph 19 of Roman numeral 5, Roman numeral 4, clause A, which points to how a speech was made by the managing director of Ajax Private Limited, Mr. Harrington, who had made a unilateral call that there should be a provision of uniform discounts across the region. However, this particular aspect in and of itself does not amount to a meeting of minds between parties, and therefore, in light of the same, it is contended that there is no evidence furthermore provided in the proposition anywhere to indicate that the algorithms that have been taken up by the parties in this regard are as a direct result of the call to action being issued by Mr. Harrington.
Council, sorry to intervene here. Why do you say what is reported in 19.4a, which is basically DG's findings, will not qualify as a plus factor? Essentially, one of the toy manufacturers MD makes a statement openly that it would be good to have uniform discounting for all toy manufacturers, and then immediately thereafter, in 2018 itself, based on paragraph 6 of the proposition, all of you employ a price algorithm mechanism where you track each other's price. So why is it not a plus factor?
On that note, Your Honor, we would draw the attention of this commission to the fact that there is nothing to suggest that the algorithms were adopted after the speech. The algorithms was simply the subject of the market study as described in 2019. But there is nothing in the problem that indicates that as a result of the speech itself, the algorithms were adopted, barring the Director General conclusion regarding the same. It is this.
I am conscious of that. Let's understand if this price algorithm was adopted after the speech. You would agree that this speech which happened and where all other participants were present will be a plus factor?
No, Your Honor. Even in that regard, mere price parallelism alone would not amount to a cartelistic agreement in this regard, considering the next limb of arguments which will be presented, stating that there is no.
Also, this is not a case of mere price parallelism. There was a meeting where one of you said that we should have uniform discount policy. Why would you have a discussion like that?
It was merely, Your Honor, it is contended that was merely a call given unilaterally by Mr. Harrington, and there was no consensus amongst the four toy manufacturers to act on the same. The principle with respect to an agreement in light of this was that the algorithms were adopted by each toy manufacturer in order to competitively adopt prices in the market. So in that manner, each toy manufacturer.
What is the standard of evidence under Section 3.3a of the Competition Act of RSM?
It would be that of a balance of probabilities, Your Honor, that circumstantial evidence would also come into play in determining whether or not such an agreement or decision has been reached.
Okay, if there is a probability that there could have been, that's sufficient, right?
Your Honor, that the reason for the prices to be similar in this regard because of the oligopolistic market structure, and therefore the prices were similar in nature. But the same is not indicative of an action towards concerted efforts to form a cartel, is what the submission is trying to say in this regard.
Sorry, just if I can just also take one question here, is just why would, because the market is oligopolistic in nature, why does that mean that prices must be similar? I mean, your toy manufacturers, is there some explanation? Is there a common cost of production? Is all the material that you're using, is it of the same? Is there very little product differentiation, i.e. all the toys that you're selling are almost identical to each other? So is there an alternative explanation for this similarity in pricing? Because that might help you.
We would point to particularly the nature of the marketplace in Russia, which is characterized by four toy manufacturers, which cumulatively have 85% of the market share. And generally, even before the agreement, that was the structure in place at the time. That would be the reason why, considering the similar nature of activity as well, the prices were always similar in nature.
That's not very convincing, no, Council. Basically, you're saying that the market was highly oligopolistic. There was high degree of price transparency, and therefore there was opportunism. You're putting down the similarity to prices to suggest that, four toy manufacturers who would have, under normal circumstances, resulted to some degree of competitive pricing had no incentive to do so because the market was oligopolistic. Are you sure that's the line you want to go down? Because that's not very compelling.
In that regard, Your Honor, we would point to how the toys in question are not particularly differentiated products, and these are all products of similar nature, and there is evidence to suggest a similar pricing mechanism even before the particular agreement. What changed after 2018 with the adoption of independent pricing algorithms, particularly, was that the information that was factored into the algorithms was publicly available data with regard to prices, and that is why there is a similar ranging of prices in that regard, Your Honor.
So, Council, I have a follow-up question on the announcement that was made by Mr. Harrington.
Indeed.
So I would like to distinguish two situations. One where you unilaterally declare your company's position, another where there is an invitation to collude by one of the competitors. And if you go through the horizontal guidelines in the EU, it also indicates an important exclusion to the safe harbor that would generally be available, and that is to say when a communication has a invitation to collude. And when we read this, it clearly says that Mr. Harrington emphasized for the need to focus on e-commerce as a channel and called for the manufacturers in Arishem to provide uniform discount. How do you not classify that as an invitation to collude?
Your Honor, the point of differentiation there would be the fact that it is not a call to collusion with respect to those three other toy manufacturers, considering that it was a general meeting of all toy manufacturers in South Asia. And as such, the declaration made was merely to preserve the interests of toy manufacturers pan South Asia in light of the threat of imported toys that was present. As such, there is no specific, form of collusion, particularly because the declaration itself is one that seeks to promote the use of e-commerce channels and strengthen the facilities in that regard. That would be the contention of the opposite parties in that regard, Your Honor. If Your Honor is so pleased with the response, in that regard, it is a submission that there is no precise meeting of minds, nor is there any concerted action at the time of 2018. And that is why it is submitted that the DG report indicating a cartel existing from 2018 should not stand in the present case. Additionally, with respect to the DG's report submissions with respect to the developments in 2020, we would draw this Commission's attention to the case of All India Tire Dealers Federation case versus tire manufacturers, the 2008 decision, wherein it was held that explicit agreement need not be proved and evidence such as conduct and intention behind the act should be considered. Applying this particular rationale to the facts of the present case, Your Honor, the intention and conduct is very clear insofar as the agreement in question of 2020 was one that arose out after the COVID-19 pandemic and not before it. This fact becomes particularly important to note in light of the context given by the council, that dwindling sale prices was present in light of the repeated lockdowns that were imposed. And furthermore, because of the main source of revenue, which was physical stores, could not be a legitimate channel for distribution in the light of the COVID-19 pandemic. As such, the intent and conduct of the parties was merely to survive the COVID-19 pandemic, and there was no specific intent to collude and fix prices in that regard. Additionally, the council will also like to seek reliance on the case of Spectrum Sports versus McKillen, a US Court of Appeals case dealing with the Sherman Act, the primary antitrust legislation of the United States of America. With respect to the when considering anti-competitive conduct on part of parties, three factors were particularly noted to be important by the court in this case. That is, first, that there is engagement in predatory or anti-competitive behavior. Secondly, this is with a specific intent of parties to monopolize. And thirdly, there is a dangerous probability of achieving a monopoly. In light of this important precedent, we note that the conduct of parties is not anti-competitive in nature, considering that on the first prong, that the defendant has...
Sorry, the case law which you cited, was that on what is predatory pricing, or was it what is cartelization, the one which you just relied on? Which was the case?
The case was the case of Spectrum Sports Inc. versus McKillen, a US Court of Appeals case. It deals particularly with anti-competitive agreements in that regard.
Counsel, does it pertain to Section 1 of the Sherman Act?
I believe it pertains to Section 2 of the Sherman Act.
Then how is it relevant?
Can you read Section 2 and explain how it would apply to Section 3.3 of the the Additional Competition Act?
Although your honor, in that regard, it talks about monopolistic agreements particularly. It is important to consider, considering that the nature of agreement in question is towards the end of monopolization of trade, and as such, there has been an allegation by the counsels for the informants in present case that this is a step taken to push competitors out of the market and monopolize the market in that regard.
Counsel, sorry, I mean, that's not relevant, right? In Section 3, the question was, is it relevant for Section 3? The whole idea of intention to recoup your losses and all of that, which comes in context of predatory pricing, that too under Section 2 of Sherman Act?
It would be relevant insofar as it still describes the nature of anti-competitive conduct, and even applying the Competition Commission's rationale of in the In re Sugar Mills case, these facets such as the intention and conduct of parties must.
Counsel, in that case, just give us an example. Five let's say shoe manufacturers sit together and say that from tomorrow we'll sell our shoes at a uniform price. Is there intention here?
No, not exactly, Your Honor.
There is no intention to cartelize?
Apologies, Your Honor. Can you repeat the example?
5 shoe manufacturers sit together. They decide that from tomorrow they will sell their shoes at same price. Is there intention to cartelize?
In that case, yes, there would be intention. But
you guys, all of you decided that you will have a algorithm which will somehow allow that for 2 months period on a rotation basis, one of your products will be priced lower than others, and it will be done on rotation basis. Is there no intention?
Your Honor, the point of contention there would be that in the examples given by Your Honor, only if the prices were set in a manner to push out competition, would it be can it be an indicator of anti-competitive actions? In this particular, the facts of the present case, it is not an anti-competitive act, considering the intention is not to push out competitors or put itself as an unfair position, but rather to survive the pandemic as well as the repeated lockdowns that had severely hindered the trade in the region. That is why, as a manufacturer that was severely reliant on physical operation of stores to run, and the manner in which the lockdowns had impeded sales in that regard, it is submitted that this would not be an anti-competitive agreement, considering the intent here is not to monopolize or create a cartel, but merely to survive.
Your argument is that...
Sorry, Pranjal, go ahead.
So I'm saying your argument is that then this is a crisis cartel. Is that what you're suggesting?
No, Your Honor, we would not say that it is a crisis cartel either, because there is no intent to cartelize and operate in that manner. It is the essentials of a cartel as per 2C are not met in this regard, considering the arguments henceforth about the agreement not being present from 2018, and also the fact that there is no specific intent to cartelize is something that has been important in lieu of the Competition Commission's decision.
So your argument is that you did it only because pandemic hit. right? And you wouldn't have done it otherwise. So, but you did it in a face of adversity, does indicate that there was indeed a cartel, although you are arguing on intentions here.
Your honor, the fact remains very clear that in 2019 the market study had already indicated dwindling sales, but there was no action taken at any point at that point in time to form a cartel and act it. If it was in fact to secure some kind of unfair advantage, it could have well happened at that point itself. But it was only after the COVID-19 pandemic and repeated lockdowns, and as a response to the same, that these actions had to be taken by the four toy manufacturers. And if your honors would allow me to continue the case, we would also argue that this has not had a clear adverse appreciable effect on competition in the region either.
Please go ahead. Diksha, you had a question.
No, I just wanted to check where exactly Section 2C and Section 3.3 talk about intent. Can you just take us through the provision and tell us where intent is referred?
Although not in the direct text of these either of these provisions, your honor, we were relying on cases and the cases that were cited, particularly the CCI's verdict as well in the tire manufacturer's case, wherein with respect to the circumstantial evidence, the conduct and intention of parties become circumstantial evidence to consider whether or not an agreement can be amounted to an agreement of cartelization or not. So the jurisprudence is what we were relying in that regard when we were mentioning intention.
Can you quickly read the passage from the tire case where intent is spoken about?
Your honor, I will do that. Your honor, may I be granted 30 seconds to continue and then come back to this to merely read
out? You can read it out in your survey buckets.
Oh, indeed.
Yeah, sorry. Actually, just one additional question, which is that is there a possibility for there to be an efficient cartel? I mean, what you're suggesting is that potentially, at least what I'm hearing you suggest, is that if there was an agreement, it was to meet certain exigencies. There was, a reason. There was no intent for you to, even if willy-nilly, that's exactly what happened. And I guess the question here is that does the statute provide you any leeway once you've demonstrated the existence of an agreement and that agreement has resulted in, even without intent, the fixation of a price or a discount? How do you justify that?
We would have a twofold justification with respect to your honor's question. The first being that the organization itself does not constitute a cartel, and secondly, that the actions in question with respect to the setting of prices do not have an adverse appreciable effect on competition in the region. Although a presumption exists insofar as Section 3.3a of the Competition Act is prevalent, it is still a rebuttable presumption, since the burden of proof then shifts onto the parties against which such an allegation is being made. In defending this proposition, Your Honor, I note that my time is about to elapse. May I request an extension of a few minutes to conclude the arguments with respect to this issue and move on to the next issue?
Perhaps just maybe just respond to this question, and if there are any other questions, and then we can wrap up.
Indeed. With respect to the adverse effect on competition, particularly, we would note the case of the Chicago Board of Trade versus the USA, wherein there's a need to the court considered that there was a need to consider it from an economic and price perspective, and it further went on to say that in that case it was observed that the rule did not have any appreciable adverse impact on general prices or the supply of goods in that manner. Applying this rationale to the facts of the present case, it is submitted that there is no discernible adverse effect on competition, considering that the prices are not being set in a manner that is too low that is extremely low to push out other competitors from the market, nor is it set too steeply to disadvantage consumers in this regard. It is merely a system wherein the prices of the other three manufacturers remain the same, and only on a basis of 2 months, one party's price is lower than the other three. In that regard, it is still the submission that the actions taken by the toy manufacturers vis-a-vis the deployment of the algorithm does not amount to an act which has a clear adverse effect on appreciable adverse effect on competition. And the counsel for the informants have tried to state that new entrants have difficulty, and it's impossible for them smaller market shareholders to operate in this market, but there is no evidence whatsoever in the proposition to support that claim. Secondly, with respect to preferential treatment also being given, it is still our contention that the treatment, that is the placement of products on Celestial's website, is solely based on user ratings and the fact that the 4 toy manufacturers have existed in the e-commerce sphere longer than Star Fox Cooperative, which has only recently taken up these measures. So due to these factors, it is the Star Fox's search results have been placed later, and there is no evidence of collusion in that regard, Your Honor. Your Honor, I note the time, and I seek an additional 2 minutes to make submissions regarding the next issue of facilitation of cartelization.
I think, Counsel, we can rest it here. Just one final question. Is the algorithm used by you to price products only on Celestial and online platforms, or does it extend to your brick and mortar store pricing as well?
On that regard, we note that it was just the pricing of goods in general. That is, the states that the products of one of the 4 manufacturers would be set for a period of 2 months on Celestial.
So only on Celestial or everywhere?
Indeed, only on Celestial, Your Honor.
Is that something you would like to take us into account? Can that have an impact on AEP? Or?
Your Honor, on with regard to that particular question, we note that it does not make a difference in this regard, considering the fact that we still contend that Celestial cannot be said to have facilitated the arrangement in this regard, and it is also the fact that the use of this algorithm does not create the adverse effect on trade in light of the Chicago Board of Trade case that we had cited previously. Additionally, just to clarify one last thing before the council ceases its arguments, although facilitation of cartelization may be an offense for which third parties can be held accountable, as is evidenced by European cases like EC Truhand, as well as in CCI jurisprudence, such as in the beer markets case, as well as in the Apollo Tires case. It is important to note that knowledge has always been an important aspect that has been held, be it in the ICAP PLC case or even in the breweries case. Often it had been considered whether or not knowledge on part of these parties was present, and in that light, it is submitted that Black Knight had no knowledge whatsoever that its algorithm was being used in the manner that it was, and also that Celestial was not privy to the fact. And also, Celestial per se did not have an intention to contribute to the objectives of the cartel as a whole, and it was merely provided services as it had been appreciated to. In that, we would conclude our submissions with respect to this the last issue as well, and state that the 2 entities, namely Black Knight as well as Celestial, cannot be said to have facilitated the cartelization in any manner.
Thank you. Just last question, which we also wanted to understand from the council from informant side. So would you please enlighten us on this issue, if whether facilitation itself is covered under section 33A of the Act?
Although not explicitly mentioned, it in the jurisprudence of the Competition Commission in numerous cases.
Okay, let's not get into jurisprudence. Just from the basis of the language of section 33A, would it include facilitation?
It would be, it can be read under it, considering that 3.3 particularly notes agreements, and it also notes practices which have the effects mentioned in 3.3A and so on and so forth. So the practice that may have facilitated cartelization can be brought under the ambit of 3.3, and as held in the, for example, in the breweries case, the facilitator, namely, I believe it was Carlsberg Private Limited, was held to be a facilitator of the cartel, namely for the fact that it was aware of the anti-competitive nature of discussions.
Understood. There's just one question which Pranjal also asked, and it will include entities who may not be engaged in identical services. So for example, in this case, although the algorithmic company, which is not in the business of toy manufacturing and selling of toy manufacture, can be facilitated under section 33A?
Indeed, it can be, considering if it actually acted in pursuance of the objectives of the cartel in question.
And what is the statutory basis to say that under section 33A? Why will it be included?
Considering that it is not an explicit statutory provision, we were using jurisprudence to establish the 3 limbs that have been relied upon by the European courts to determine whether or not a third party should be liable as a facilitator. And as per that jurisprudence, it had knowledge, the intent to to contribute to the goals of the cartel, as well as actual contribution, were seen as the three main factors for which a facilitator can be held liable for cartelization in that regard.
I understand you correctly that under 3.3a wordings is strictly, without getting into jurisprudence, the algorithmic company cannot be held liable just on the language.
It may be if it is found that the practices in question were in fact actually facilitating the cartel, because of the fact that 3.3 covers not only agreements but it also deals with practices that may be adopted in that regard. So miscellaneous party that still renders services, although the services may not overlap with the same services as provided by the members of the cartel, it can be held liable as a facilitator, and practices or decisions can thus be covered under 3.3a as well.
Thank you.
Much obliged, Your Honors. Would Your Honors require that the council places the prayer on record before this commission?
I don't think that's necessary. Thank you.
Much obliged, Your Honors. It was a pleasure arguing before this commission.
Thank you.
Your Honor, before starting the rebuttal round, with your permission, I would like to you to inform that the informant team has already taken 46.5 minutes of their time out of 45 minutes, plus an extension of 2 minutes was allowed to the speaker 2 of the informant side. And the opposition party has used 54 minutes of the time given to them without the rebuttals and sub-rebuttals. So with your discussion, you can allow them for the rebuttals and sub-rebuttals round with an extension of time of raw value.
How much time have they requested for rebuttal and sub-rebuttal?
Both of the team requested for 2 minutes each.
So let's just give them 2 minutes each.
Agreed. Let's stick to the 2 minutes though.
Indeed, Your Honor. May the council proceed with the rebuttals? Indeed. Your Honor, coming to my first point, the relevant market defined by the respondents. Your Honor, as Your Honor rightly pointed out, it is that dynamic concept, and the fact that the opposite parties have stated that the online and offline markets are different markets in the facts and circumstances is factually wrong. Are factually wrong. Your Honor, they have heavily relied on paragraph 6 of the Moot proposition to state that that it appealed to its consumer base. Your Honor, but if we just read the next paragraph, that is, after 1 year of the said fact, their profits through the sales and brick and mortar sales were declining. Your Honor, that fact combined with the fact that the market study given in paragraph 9 and the major shift due to pandemic, it can clearly be established that they were equally two different markets in this particular relevant marketplace. Hence, Your Honor, it clearly established the fact that the argument put forth in the issue of dominance by the opposite party does not stand because they relied on the wrong relevant market definition herein. Now, Your Honor, if we come to the issue of abuse of dominance, they have stated that in the case issue of preferential listing, they have other options to purchase the same goods. Your Honor, but they have failed to appreciate the fact that various researchers related to consumer psychology related in e-commerce established the fact that mostly the clicks and the purchases on an e-commerce platform happens only on the initial pages of the e-commerce platform. Hence, by giving them the preferential treatment and by not giving such treatment to the non-preferred seller, it has constructively denied access to the non-preferred sellers. Your Honor, coming to the second issue, they have not given any plausible explanation of their act which could absolve the burden upon them to prove that there was no AEC under section 3 clause 3. Also, Your Honor, they have heavily relied on that there was no intent behind forming the cartel. Your Honor, but even if the intent was good, but it still has, but the cartel still has an AEC, then it could be penalized under section 3 clause 3, and the intent would be immaterial here. If Your Honor may give 10 seconds more, the time's up. May I?
I think we should just wrap up, if that's okay.
Indeed, Your Honor. It was a pleasure arguing before this honorable.
Your Honor, just confirming if I'm audible before beginning. Much obliged. Your Honor, with respect to the rebuttals pertaining to issue 1, it is our submission that the facts of the case merely show a consumer preference for the same, and it is insufficient to conclude that a separate market exists, since consumers still have both offline options as well as other e-commerce actions available to them. Secondly, with respect to the alleged discriminatory treatment, it is still humbly submitted that the algorithm in question is uniformly applied across all retailers and products. In this case, the learned counsel for the informants are alleging that simply because of the poor performance that Star Fox has had, owing to the fact that it is newer to the, which is actually due to the fact that it is newer to the placement of goods on e-commerce platforms, this that in and of itself cannot amount to a discriminatory treatment, and the extra commission is for other services, not for the placement in and of itself. Additionally, it is our submission that with respect to issue 2, the plausible explanation in question is what we had argued in terms of the COVID-19 pandemic and COVID-19 pandemic and the response to the same. That forms a plausible explanation that to recuperate for the economic losses that had devastated businesses across Arisham, that is the reason why such actions were taken, and the same should not be considered to be an action without a plausible explanation. Lastly, I would use the rest of my time to merely read out the case as directed by Your Honor. Basically, in the case of INRE, All India Tires Dealers Federation versus tire manufacturers, at paragraph number 297, it was particularly noted, as it is seen from the construct of the aforesaid provisions, there is no need for an explicit agreement for existence of an agreement within the meaning of the Act. The same can be inferred from the intention or conduct of the parties, and that is why we had noted that intention of conduct of the parties are particularly important to note in the present case, as there is no particular intent to cartelize or push other competitors out of the market, but it was merely to survive the negative impacts that the COVID-19 pandemic had, and particularly the disproportionate impact it had on toy manufacturers in the region. The same case can be found on page 59 of the compendium. With that, we conclude the rebuttals, sir rebuttals. Much obliged, Your Honor.
Thank you. Does anyone else have any questions, or should we conclude?
The
To
opening
conclude,
numbers
I
will be
guess.
right.
Yeah.
So we can
Yes,
conclude.
Yes, good afternoon, judges. So you will be shifted to a separate room where, in case you want to deliberate amongst yourself, you can do that, while the speakers will be shifted to another room.
Yes, ma'am. Your Honors, I'll just quickly shift you to courtroom number 1, title courtroom number 1, where you can deliberate amongst yourself as to who should win. You shall be getting a prompt within the next 30 seconds.
Super. And just to thank everyone to all the speakers. Excellent job. Well done, guys. Don't lose your interest in the subject. It's important enough. So well done.
Thank you so much, sir.
Thank you very much, Your Honor, and I would also like to congratulate both the teams for reaching the final round.
Honorable judges, you should be getting a prompt right about now to join the judges' lounge.
Professor Srijat and Professor Gupta, we're just hoping that the judges will finish their deliberations soon and they will be back here as soon as possible. So I just wanted to convey that to everyone.
Thank you.
Okay, thanks. Thank you.
Thank you.
Respected teams, all the judges are here. Your Honor, sirs and ma'ams, I would also like to introduce Professor Aman, Professor Indranath, and Professor Srijit, senior faculty of our university. You may please proceed with the feedback for the teams.
Excellent. Thank you all for the time. I think it was absolutely fantastic to hear, for such eloquent, confident, articulate speakers. So hats off to all the speakers today. I mean, of course, as we all know, behind great speakers are even better researchers. So hats off to the team as a whole. I know this is seldom the victory of just one or two. I think just the fact that many of you guys have made it to the finals itself is testament to your success through and through. So congratulations. I think we thoroughly enjoyed as a group of four, your advocacy, your poise, and your presence. So I think all in all, we were all very pleased, which made this decision difficult, of course. But someone's got to win, and someone's got to be second. So I guess in terms of feedback, I think Diksha is going to come in and tell us who came in first and second. But in terms of feedback, maybe I just share a few general thoughts for all of us, given that we are predominantly practitioners and then academicians, if at all, second. I think the few things that we tend to focus on and we've learned to do is basically know your first principles. Right? There is always room for advocacy. There is always room for being able to get judges on your side by being forceful. So there's always place for courtroom advocacy, but I think nothing replaces fundamental knowledge of the law, knowing your first principles, knowing your concepts well. And I think to that extent, perhaps as general feedback, I would suggest that two things stood out today, which was is that this is a small but new law. I think there are some of you who started to blur the distinctions between some concepts, potentially between abusive dominance, dominance itself, cartelization. Know your statute, right? Know when you saw so many of the judges ask you the relationship between section 3(1) and section 3 subclause 3. Do dive into it and try and explore those answers beyond the obvious. And then I thought that there was sometimes perhaps a slightly simplistic use of terminology. Terminology is fraught with context. It's important to understand one to be able to use the second. So when you use terms like network effects, so on and so forth, be certain about what its implications are from a broader antitrust perspective. I was sharing with our judges a little while ago where we were in a courtroom once where the Solicitor General for India was arguing a very important competition law case and suggested to the Chief Justice of India at that time that, well, your lordships, I'm sure you understand that there's a big difference in marginal costing. So the Chief Justice of India, who was then also a chartered accountant, turned around saying that, learned solicitor, what do you mean by marginal cost? So he turned around and says, your lordships, I think he was a bit taken aback at being asked such a basic question, but it happens even at the highest court of the land by, the Chief Justice of India himself asking the Solicitor General of India himself. These are the questions that come. And I think he was caught a little bit on the back foot. And while he did his best to wriggle out of it, I think one of the things that he said was, well, the lordships, is where the cost, there is a margin in the cost. So he was quite literal in his explanation, which of course the Chief Justice, being who he was, had a good laugh about. So I think it's quite important that we understand, for example, network effects doesn't quite literally mean, a network of effects. So I think it's useful for us to understand the terminology that we use, be true to your Bear Act. If there was one thing I would take away from this moot would be, focus on the statute, focus on the statute, and focus on the statute. If you know that inside out, I think everything else is an add-on. So I'll stop there. Once again, a fantastic job done. All of you, truly creditable. And I'll hand over to my other judges in case they'd like to make more specific remarks with respect to each of you. Diksha, perhaps you should start first.
think no specific remarks. First of all, congratulations to each and every one of you. It was a remarkable final round. All of us thoroughly enjoyed ourselves. You covered a lot of interesting, and I'm sure what is to you fairly new areas of law. So I hope, as Sami said, you continue to like the law and you continue to explore the law. There'll be nothing more than we as practitioners would like better, to have more and more practitioners come into this area of law. And this is something that I have experienced all throughout in my mooting career as well. And this is a small little thing for you all to remember. Listen very carefully to the questions that judges pose to you, because at times there is an answer that we're giving you. There's some form of an assistance that we're throwing your way, and try and understand the context of the question so you can pick it up and frame arguments. It always comes very handy because all the judges who are sitting on the table, they want to help you out. We're not bad people. So please be very, very careful and vigilant to what questions are coming your way, and maybe you can find a quick way to get out of some sticky situation that you're in. But otherwise, congratulations. You were all amazing. And over to Pratik or Pranjal or Parth if they have any other comments, feedback.
Sure, Pranjal, you want to go ahead?
No, please, Parth.
Sure. So thanks Diksha and Samir. I think both Diksha and Samir have covered everything, and I'll just add 2 points based on my own mooting experience in days in back in law university. I don't judge moot so often now. I mean, previously when I just graduated, or I used to judge it more often. But 2 things. One is that it's always in a problem that there's certain issues on which one side finds it difficult, and that's how moot problems are always framed. Like there will be some issues on which one side will find difficulty about it, and the challenge there lies, or I would say that that's an opportunity for you actually, because typically arguments they are given on those difficult issues. If you're able to come out with innovative arguments, an argument, of course, this is not a decision which is going to happen. We all know it's an exercise of moot court to decide which team is better on that day, on particular day. So if you're able to come out with reasonably innovative arguments, which at least answers an issue on a prima facie basis, at least during that 45 minutes of interaction which you have, so that a judge is able to, digest that argument, that's the beauty of a good speaker, I would say, or researcher or team for that matter. And that is something which you should always remember, that there will be no, answer which answers everything. It's not possible. Moot problems are framed in a manner that there's too many open ends. Facts are always not clear. It's not a real case. But there has to be some level of answer, even on difficult questions, issues which are difficult, where you are able to at least satisfy prima facie to the judge, this is my position, and that works. I'll tell you in my experience. And number 2 is that, which is a general advice going forward. One team, as Samir said, will win. One team will be second, and you should not take it to heart, your hearts. And I'm telling it from my own experience. Not every time you will win. Not every time you will get the best speaker award or best memorial award. And that should not deter you from participating in moot court competitions. You should continue to participate in moot court competition as much as you want. Those 5 years are limited. I stopped moot court participation at a point in my time, and trust me, 15 years, 16 years after you have graduated, none of this matters actually. So therefore, please continue participating. This is very important. So I'll stop here. Thank you.
Thanks, Parth. And I think all the judges have sort of spoken their heart, very useful points. Wish I could have judges like that when I was mooting back in the days. But I think just one last point, perhaps, to just sum it up. I think at some occasion we saw that judges were asking a question sort of, or rejecting your argument on a particular point. But then we saw those kind of issues coming back, someone still arguing points on the same line. So for example, if someone said that, well, we looked at US cases, or someone cited EU cases or whatever, and some judge remarked that, well, it might, we're looking at something closer to home, for example. Then I think your one part of your mooting capability will also be to adapt. So if the flow of arguments or judges are not appreciating something, then I think moving on, even though you would have structured your arguments in a particular way, adapt to the situation and perhaps make a course correction. You need not argue on the same lines as you had previously decided. so you can change and adapt to the situation and sort of take take from there. So I think that's one bit of advice. But otherwise, excellent. Both teams were really good. It was a close fight. So best of luck to both sides.
Thank you so much to all the members on the panel. I sincerely request you to declare the winning team in the final round.
So we all had a very tough time thinking about who the winner would be, because both the teams were extremely good. And I think as Parth and Samir already said that, there's always a winner, there's always a loser, or let that not ever deter you. But today, by a very small margin, we found that Team 2 was the winning team. So congratulations to Team 2, all 3 members. You did a great job. Not to say that Team 1 didn't. You all were amazing as well. But just because we had to decide a winner. So congratulations.
With this, we would officially like to begin the valedictory ceremony. I will hand it over to one of the student OC members, Pranav Matapalli, to begin the valedictory session. Thank you very much.
Thank you so much, Professor Sharma. So again, very good afternoon to all the judges, all the participants, our senior professors, students, and everyone joining us on YouTube today. I extend my warmest welcome on behalf of our university, OP Jindal Global Institution of Eminence deemed to be university, for the valedictory ceremony of the 5th Jindal Moot Competition 2022. Again, I would like to extend my warmest thanks to Mr. Samir Gandhi, Head of Competition Law at AZB, Ms. Diksha Manchanda, Partner at Chandok and Mahajan, Mr. Parsarathi Jha, Partner at Economic Law Practice, and finally, Mr. Pranjal Pratik, Partner at Khaitan & Co., who comprised of the judges of the final panel. I would also like to extend a special thanks to Ms. Diksha Manchanda for drafting an amazing moot proposition. As of this now, I request the final judges to make any remarks if they want to. I mean, apart from the team feedback, if any remarks are, any judges wish to make any remarks, I request you to do so.
Thank you. Thank you for having invited all of us. I think it's always a pleasure for us as practitioners to be called back to law schools. I think it's what we owe to the profession, having been there and done that not so long ago ourselves. So it's very much both a pleasure, but also an obligation for us to remain invested in the future of legal education, of which OP Jindal is such an important part. I think back when I started my journey with the law, I was a default lawyer, first generation, didn't quite know why I was doing it, apart from I would get in nowhere else. So I was packed off to a train to a city which is notoriously known for being packed with capitation colleges. And I had an old lady sitting right next to me who turned around and said that, what are you going to do? Because it was college season and she could see I was like, I'm going to do law. It's like, what a loser. I mean, no engineering, no, doctor nahi banna hai, vagera, vagera. And then after that, you're like, but why Bangalore? Couldn't you find something closer to Delhi? And I had to explain to her, which is that, it was something new. It was a chance to try and break out of the traditional stereotype of being a lawyer. And I think we've come a long way since then. And I think what you folks are doing out in Sonipat is truly very much part of this journey. And it's great to see such incredibly bright and articulate lawyers during the course of having done the odd guest lecture at Jindal, along with Professor Shilpi Bhattacharya and others, but also over the course of this moot court. So the only I am not in a position where I can offer words of wisdom or advice, but I will just say that this is mooting is part of the journey. Let that help you, but not detract from the larger law school experiences, which is sometimes more outside of the classroom than it is. I think it's very much something which is enriching, and I think there is a larger part. I will kind of wind up by saying something that I was told by our founding director, which is that you are, at the end of the day, our project here is to be social engineers, which is, of course, I think it's a touchstone. So many of us join corporate law firms and so on and so forth, and there's absolutely nothing wrong with that. despite what my founding director thought of us. But I think there is a lot to be said about, ever so often reaching out, as you will during the course of your immensely successful careers, to realize that your position as lawyers in this profession needs to be viewed from that prism. How much you contribute to society more generally, how you view your role as a social engineer, and whatever you do, I guess, as you are doing today, make the best of it. So congratulations to all of you. Thank you for inviting me in particular. It's been a pleasure.
Thank you so much, Samir sir. Would any other judge like to say some words?
Sure. So I think I concur with Samir fully. No need to repeat that. I congratulate the entire organizing committee members and students for organizing this. And I say this with utmost sincerity because I have I understand what I'm saying. I have been through this. As a student, I have organized Moot courts, and that was on competition law in collaboration with Competition Commission of India. So I understand that how much time, energy, and more importantly, emotions get into organizing this. And I'm sure it would have been very challenging for you to organize it on a virtual mode. Of course, had it been physical, it would have been a much better experience for everyone. But I fully see the efforts which have gone into this, and therefore congratulations to the whole team, faculty, students alike, and all the participants who have taken out time to contribute to the success of the competition. So I'll rest with that, and thank you very much.
Thank you so much, Mr. Path. That means a lot to us. Mr. Pranjal, Ms. Diksha, would you like to say a few remarks?
Nothing much from my side. I think the other two speakers have summed it up very well, but I felt very welcomed. I see a lot of sincerity in how you proceeded with the entire Moot. So many congratulations on holding such a successful event, and I hope that it grows over the years. Thank you. Thank you.
Thank you, Mr. Pranjal. Ms. Diksha, finally, would you like to say something? Really sorry for.
Yeah, so there is the very specific perils of being the last speaker, especially after somebody like Samir and Parth. They've beautifully captured, Pranjal and I both faced that. They've both beautifully captured everything around the competition. There's nothing much for us left to say. So I would just say congratulations to all of you. It was brilliantly put together. The organization committee, I've been interacting with you, I think, for the past 3-4 months now in the duration of drafting the problem. The input that came from all of you was so excellent. And it's always, as Samir said, just so nice and warm to go back and in any way be connected with what happens inside the law school. It's always a very warm, fuzzy memory that it conjures up in my mind. So thanks a lot for inviting me. Congratulations to all the participants. You are why the competition is successful. You are the reason why it is good. So congratulations for participating and for being interested in this very small niche area of law. We hope to see each and every one of you in the profession. I'm sure you'll be brilliant. You'll be the stars that you are destined to be. So thanks a lot, everyone. And congratulations again.
Thank you so much, Ms. Dikshanda. Again, not wanting to repeat, but the problem was fantastic. Now, thank you all for your kind remarks. Now, I'd quickly take 2 minutes to just introduce as to what the main sponsors of the Moot, which was Jirico. Now, the first in association with the Jindal Initiative of Research in Intellectual Property and Competition. This was a think tank established in 2015 with OP Jindal Global University. The primary purpose of the establishment of this think tank was to inform and contribute to public policy making by undertaking cutting-edge research and high-level deliberations on topics at the interface of intellectual property, competition, and technological innovation. I am pleased to announce that Jirico has received research grants from big institutes like Qualcomm Corporation and the European Union to conduct conferences, workshops, and pursue research on the related fields. The current body members of Jirico are Professor Dr. Indranath Gupta, Professor Vishwas Devia, Professor Avirup Bose, Professor Dr. Ashish Bharadwaj, and Professor Dr. Manveen Singh, all well-known scholars and experts in the field of competition, IP, and technology law. Now, Professor Indranath has been awarded the prestigious Jean Monnet Chair by the European Union for teaching and research for the project, quote, multidimensional approaches to the understanding of the EU data protection framework. I am pleased to announce that Professor Dr. Indranath Gupta is present with us today as well. Now, Jindal Global University is only one of the 2 universities in India and only the private university in the country to receive the chair in 2020, the other being JNU. JGO has also secured the largest grant amount awarded by the European Union for the Jean Monnet Chair in India. Now, Jericho has successfully organized the past 4 editions in association with the Moot Court Society of Jindal Global Law School. And the previous editions were held physically, but unfortunately, due to the pandemic-induced constraints, we were unable to organize this event for the past 2 years. Therefore, we are extremely glad to relaunch the same through a virtual format. Now, without further ado, I would now like to invite Professor Dr. S.G. Srijit to speak a few words. Professor Srijit is currently serving as the professor and the executive dean for Jindal Global Law School, and is also serving as the executive director for the Center of International Legal Studies. And he also holds a doctor in law from the University of Lapland. Professor Srijit, over to you.
Thank you. Thank you very much. It's a wonderful afternoon, and I was listening to all the judges. It was so refreshing and heartening to hear them emphasizing participation as against winning. And as they were speaking about the importance of participation, I was just trying to reflect on the philosophy of Moot Court. What is this idea which has today manifested as numerous prestigious competitions before us? Well, fundamentally, the Moot Court was an extension of the Socratic method, which was taught, which is generally followed in American law schools. The law professors felt that, well, there is a certain randomness in the Socratic method, and they need to institutionalize this by setting up a context and an experience of assimilation. And moot courts in the 19th century moved from classrooms to a co-curricular activity. Well, of course, the madness of competition was not there at that point. So fundamentally, this is a pedagogy. Well, I call it a madness because that at some point, that we forgot the pedagogic utility of the moot courts and began to view them more in terms of the competitive spirit. Well, it's good to have the competitive spirit, but as the judges mentioned, is it all about the moot court? Well, I remember Lewis Carroll in Alice in Wonderland sardonically writing, "In my youth, I took to law and argued each case with my wife. The muscular strength it gave to my jaws has lasted the rest of my life." Well, is moot court all about oral argumentation? Perhaps not as much as Lewis Carroll sardonically put it. It is about argumentation. Argumentation includes the ability to think through the law. It includes the ability to prepare like a lawyer, think like a lawyer, and present things like a lawyer. But of course, moot has always been a matter of contestation. Moot has always been a matter of deliberation among the law professors as well. There are times when moot court came under the scathing attack that, is there too much of moot and less of a court or not? Well, in responding to this, academics have waxed eloquent that, well, moot doesn't contribute much to the court because there is no ambience of a trial. But we all understand that moot court is a sort of simulation when it comes to appellate litigation. But beyond all that, I've mentioned that there is a pedagogic utility to the moot court. I hope that the pedagogic utility of the moot court, the education which the moot court provides, never evanesces in the competitions. I could hear from the words of the judges that our students and the participants kept the spirit of the moot court alive as they participated in this competition. In that sense, everybody who participated in this moot, they got educated. Everybody had an experience in pedagogy. All of you kept the spirit of the competition alive. So that means there is no winner, there is no loser. Everybody is a winner. But some one of you will today be judged as the title holder. That's what the difference is. So I hope that in future as well, that we don't get into the madness of the competitions. Rather, we'll focus on the spirit of the moot court competition and keep the spirit alive to broaden our own horizons and understanding. Thank you very much. And I congratulate the organizers of this moot, Jericho, especially my colleagues, Indranath, Vishwas, Ashish, Avirup, and Manveen in particular, and the Moot Court Society of Jindal Global Law School, all the office bearers and students involved with that. And I also take this opportunity to thank all the fantastic judges and also the drafter of the moot court problem. Even though I could not hear all the rounds, but from the words of the students, from the words of the judges, I could hear that, well, that competitive spirit has been kept alive without letting the pedagogy to lose out. Thank you very much.
Thank you so much for your remarks, Professor Srijit. It means a lot. Now, I'd just like to introduce Professor Indranath, the head of Chirico. Professor Indranath, would you please like to speak a few words?
Thank you very much for inviting me. Good afternoon to all of you, and thank you very much, judges, students, and I was really fascinated to see the problem, little what I could contribute to the problem as per comments, and I really thank this Diksha for spending time, and for the judges for spending time with us, and students, of course, and the participants who have been part of this moot court for the past 3 days. I must thank all my colleagues, Shama, Ronak, Shilpa, and Aman, and of course my dear students who are part of the OCS and the organizing committee. We thank you all on behalf of Jericho. Jericho, as you have explained, Pranav, I cannot add anything further to that, except it's a vision, and we are going somewhere with Jericho in terms of working closely with different agencies, working closely with different funding agencies, and producing fairly reasonable articles and work that are fairly useful to different stakeholders. I can't say more except that it's been a splendid afternoon for me. I happened to catch some of the arguments in the final rounds, and I was truly enthralled by how things went. Thank you so very much, and thank you once again for inviting me. Thank you.
Thank you so much, Professor Indranath, for your remarks. Now, the moment that the participants have been waiting for, I would like to invite Professor Shilpa for the awards to announce the best memo, the best oralist, and the names of the winning teams. Professor Shilpa, over to you.
Thank you so much, Pranav. Good afternoon to everyone, and I hope I'm audible to every one of you. Firstly, I have to welcome all of you. I am Shilpa. I'm a faculty coordinator of the Moot Society and an assistant professor at the Jindal Global Law School. Thank you so much, judges, for your time and the effort. I mean, it truly means to all of us, because of you, this Moot came into existence. And I have to firstly thank Jericho for giving us this opportunity. And I'm sure that, all of us have already expressed our thank to the members, but I would like to especially thank the staff members of the Jericho, like Ms. Isha Gaba, Ms. Navreet Kaur, and Ms. Shruti, for their cooperation, support, and providing this and providing their support as and when we need it. To give you, what I really consider that, why this Moot has particularly stand out, because of course, the requirement that it had in terms of competition law and technology, and of course, the most important fact that, the Competition Commission was a forum over here instead of a High Court or a Supreme Court, which is usually that we see in the Moot. So, and then of course, I have to congratulate and thank all the student Mooters, in spite of having their semester exams, in spite of having the issues that they're facing in the middle of the pandemic, they have still gracefully argued in front of this amazing panel. So let me just not waste a lot of time and move on to the awards, and I'm sure everybody is waiting. So let me announce the winning team. It's Christ University, Bangalore. It consists of Mr. Ritvik, Mr. Joel Jacob, and Mr. Yash Chadda. The runners-up are the team from Dr. Ram Manohar Lohia National Law University, Lucknow. It comprises of Mr. Kartikeya Agrawal, Ms. Vidushi Pandey, and Mr. Aman Jaiswal. Congratulate to all the teams. You have done really wonderfully well, and I'm sure the feedback that you have received from this prestigious panel, and I'm sure that you know what you have done so well and so right that you deserve this award. But it's not like the other teams who could not make it to the finals. It's not like that you did not, but there is something that, ifs and buts that you may have missed. And that's why, you couldn't make it to the finals. But I really wish, and I give congratulations to all the team who did participate. Moving on to the speakers. For the final rounds, the best speaker is awarded to Mr. Joel Jacob. The second best speaker for the final rounds is Mr. Ritvik G. Wonderful, and I'm sure the judges were extremely happy to hear you, both of you, mooting, and they were in consensus that the award should be given to both of you. Moving on to the prelims best speakers. The best speaker for prelims round is Miss Mansi Subramaniam from Gujarat National Law University. And second best speaker goes to Miss Khushi from Rajiv Gandhi National University of Law. Moving on to the best memorial, the informant side, it goes to Government Law College, Bombay. And the best memorial from the respondent side goes to Gujarat National Law University. My heartiest wishes to all the winning teams, to all the winning participants. And yes, I I move forward to, I think this is it from my side again, and I move on to, please Pranav, take over. Thank you so much.
Thank you so much, Professor Shilpa, for announcing the awards. And now, with that, I would now like to invite my fellow OC member, Damini, for the concluding remarks.
Thank you so much, Pranav. I hope I'm clearly audible and visible to everyone here. At the outset, I would like to extend a warm welcome to all participants, esteemed judges, and everyone who has joined us today on YouTube live stream to view the final match and the valedictory ceremony of the 5th Jindal Moot Court competition. Without further ado, I shall now proceed to delivering the vote of thanks on behalf of the entire organizing committee of this 5th edition of the Jindal Moot Court competition. There are specific individuals I would like to specifically thank for extending their unconditional support throughout the strenuous preparatory phase of instituting this moot and ensuring that this event is an enjoyable experience for all stakeholders. First, to the final panel of judges adjudicating the grand finale, Mr. Samira Gandhi, Mrs. Diksha Manchanda, Mr. Parth Sarathi Jha, and Mr. Pranjal Pratik. We are truly, truly grateful for you, not only for your participation, but for your valuable insights during the round. Akin to the sentiments of enthusiastic mooters like me, I am certain that the participants significantly benefited from your feedback and the holistic experience fostered during today's round. Thank you so much for taking out the time out of your busy schedules and joining us on a Sunday. It was a pleasure hosting you, although unfortunately in a virtual space. A special mention and a massive thank you to Ms. Diksha Manchanda, our problem author. Thank you so much, ma'am, for curating such an engaging proposition. We are deeply indebted to you for your invaluable contribution to this year's edition of the Jindal Moot. An entity that I would like to express my sincerest appreciation towards is the Jindal Initiative on Research in IP and Competition, JIRICO. The editions of the Jindal Moot Court competition over the years have been organized and held by JIRICO in association with the Moot Court Society at JGLS. I would like to express my deepest gratitude towards the distinguished current heads at JIRICO, Professor Dr. Indranath Gupta, Professor Vishwas Deva, Professor Avirup Bose, Professor Dr. Ashish Bhardwaj, and Professor Dr. Manveen Singh. Professors, we are immensely thankful for the degree and nature of support, institutional support rather, that you have extended across all editions of Jindal Moot. Your constant support has definitely been the pillar that the organizing committee has stood upon for turning this moot into a successful reality. Thank you once again. To the JIRICO administrative heads, Ms. Isha Gaba, Mrs. Navreet Kaur, and Ms. Shruti Bhushan, thank you so much for your additional efforts and help in furthering the cause of mooting. I am extremely grateful to the JGLS administration for extending profound institutional support that made today's event possible. I thank the Office of the JGU Vice Chancellor, Professor Dr. C. Raj Kumar, and Professor and Executive Dean at JGLS, Professor Srijit, for cooperating with all our persistent requests at every instant with such gracious patience. To all the participants, I hope your experience over the last 3 days of this event were at par with your expectations and beyond. I commend you for your participation and extend a heartiest congratulations to all the teams that participated. The caliber of your legal submissions reinforced a competitive environment, inducing an enjoyable experience for all of us. Additionally, no moot competition can be seamlessly organized without the support and dedication of the courtroom staff. To our volunteers, who are mainly from their sophomore and second years, You have shown great persistence and dedication while rendering your service with great enthusiasm to ensure the success of this event. A special mention to the courtroom assistants for the final match. Aryan, Karina, and Saurabh, thank you so much for your best efforts. To our esteemed faculty coordinators who have relentlessly worked with us through the entirety of the preparatory phase of this moot, I extend my heartfelt gratitude to Professor Shama Banu Abbasi, to Professor Ronak Jaiswal, Professor Shashank Maheshwari, and Professor Shilpa Singh. Thank you so much for guiding us in our respective verticals. You have taught us how to be able administrators, or at least strive to be one in our capacities. And for that, we are truly grateful. Reaching out to the larger JGU community, especially in this virtual space during the moot, would not have been possible without the support of our audiovisual team at JGU, who have been working tirelessly as our background heroes to conduct a moot of this nature on a virtual platform. Last but not the least, the group of individuals without whom this moot would not have run as smoothly as it has. Words fail me to emphasize the dedication and sheer willpower with which each of the core members of the student organizing committee has taken on this behemoth task. Pranav Matapalli, Shubham Mishra, Tanisha Gupta, Ishani Saxena, apologies, and Aditya Arvind. Each of them have been an integral and active part of this competition. Be it for coordinating with the judges or to ensure that the links of this event are unfettered, they have worked tirelessly to ensure that this event does not face any degree of a hiccup whatsoever. Thank you so much. It has been an absolute pleasure and delight working with all of you. With this, I hereby conclude the 5th Jindal Moot Court Competition 2022.
Thank you so much, Damini. You omitted your own name while thanking everyone. Well, with the consent of all the parties present here, I'd just like to take a final photograph to commemorate the end. I request everyone to smile. Thank you so much.
Thank you.
We hope you have a great remaining Sunday. Take care. Thank you so much.
Thank you, everybody. So much, all the judges.
Thank you, everyone.
Thank you.
Thank you.
Thank you.
And best wishes to the team, to the winning team, and the runners-up team.
Congratulations.
Thank you.
Congratulations.
I think the judges have left. Okay, I'll just stop. Okay.
Everyone's left.
No, the live, the YouTube stream is still going on. So let's join in another courtroom. Should I just, everyone we can just go to the judges lounge maybe?